Good morning, everyone. Welcome to the Journal of Law, Technology, and the Internet's annual symposium. Today we'll focus on AI, NFTs, and cybersecurity. We're gonna first have a video from our faculty advisor, Rachel Walbers. She cannot be here with us today, but she is in New Zealand and has recorded something for us. And then we'll get started shortly. Thank you.
Rachel Walbers, the faculty advisor for the Journal of Law, Technology, and the Internet. And I'm so disappointed that I couldn't be there in person to join you for this amazing symposium. We have a phenomenal program in store for you. Before we get into the program, I really wanted to first start by thanking the Spannenberg Center for partnering with Jolty to make this happen and bring many of our speakers to Cleveland to continue the conversation with those of you in the room. It's truly amazing to see the Case Western Reserve law community come together to put on these high quality events around programming that's really important for the future of technology and law. So if you're wondering today how we came up with such an amazing title for today's event, The Digital Frontier, Navigating the Future of Law in the Age of AI, NFTs, and Cybersecurity, you would have to ask ChatGPT, because as a group of tech lawyers, creativity is not always our strong suit. And so we did outsource it like any good lawyer would do to AI. And this is definitely a topic, both ChatGPT and AI, that I'm sure you will hear a lot about throughout each of our panels today. So what are we doing? This event is bringing together attorneys and experts working on the most cutting edge technology policy issues, including AI, NFTs, and cybersecurity. And while these can seem like disparate technologies, we hope to weave common themes throughout the sessions today. And we've brought together legal experts, authors, and practicing professionals who will take a look at legislative developments, best practices for lawyers, and cutting edge technologies in these fields, all while offering both insights into how they can work together to create new and valuable solutions, as well as help solve some of our biggest and pressing challenges. So first up, we are going to look at the way AI has transformed the way we live, work, and communicate. Nooper, who is the editor-in-chief of Jolty, will be moderating this session along with our speakers, two of which are authors of articles published by Jolty and another professor here at Case Western. This panel will look at issues relating to the new risks and opportunities presented by AI, including how to better protect privacy as well as artists' legal rights. Next, we're going to hear from Josh, who is not only a member of the Jolty editorial board, he is also one of the authors of the articles we are publishing in Jolty on this topic. Josh and his panel, which includes the chair of the Filecoin Foundation, as well as an award-winning filmmaker and a law professor. And I know this may sound like the start of a tacky joke, but it's a really great example of how cross-cutting nature the field of NFTs really is. This panel will look at how non-fungible tokens, which are a new type of digital assets that use blockchain to create use blockchain technology to create unique, verifiable, and valuable tokens, which can represent anything from art to music to gaming to collectibles. And so while these NFTs can offer new and exciting opportunities, they also raise questions about legal ownership, authenticity, and copyright. And finally, today we will be listening to a panel moderated by Gianna, who's Jolty's incoming editor-in-chief for next year. And this panel will be looking at important cybersecurity issues. Her panelists include one of DC's top cybersecurity policy experts, a practitioner in the field, as well as an author of a Jolty article, which looks at the law of war and cybersecurity. As you all know, cyber policy remains a critical concern for many individuals, organizations, and governments alike, as cyber attacks become more frequent, sophisticated, and damaging. This panel will highlight the intersection between AI and NFTs, as well as cybersecurity, bringing it all together again, and how all three of these technologies can raise important challenges as well as opportunities to protecting digital assets, detecting and mitigating threats, as well as enhancing privacy and security. So with that, I will turn it over to Nooper, who is the person in the room who's going to start our first panel. I encourage everyone in the audience to ask questions, dive deeper, as we hope this will be the start of an ongoing conversation. And we're really proud from the Jolte team, as well as the Spannenberg Center, to bring you all together. I hope you enjoy and look forward to seeing you again soon. Thank you.
Thank you to Rachel for the wonderful introduction from New Zealand. It is my pleasure to welcome you to the Journal of Law, Technology, and the Internet Symposium panel on AI and the law. As we gather here today, we find ourselves at a crucial juncture in the evolution of the legal field. As we grapple with the unprecedented challenges and opportunities posed by the increasing use of artificial intelligence in the practice of law, AI has already begun to transform the legal landscape in profound ways, from enhancing the speed and accuracy of legal research and document analysis to enabling new forms of legal decision-making and dispute resolution. But as AI continues to advance and expand its reach, it raises important questions about the role of lawyers, the ethics of AI decision-making, and the potential for bias and discrimination in automated legal processes. Our distinguished panel of experts will explore these and other related issues to AI and the law, drawing on their deep expertise in a variety of related fields, including computer science, law, ethics, and policy. Through this discussion, we hope to shed light on the complex and evolving relationship between AI and the law, and to chart a path forward that maximizes the benefits of this powerful technology while also ensuring that it remains accountable, transparent, and just. Jamison E. Tibbs is an attorney and IP practice team member at Lippis Mathias and an adjunct professor of copyright law here at Case Western Reserve School of Law. Professor Tibbs assists clients with a range of IP matters, including copyright licensing and protecting music, art, and software in the fields of electrical engineering and computer science, with a specific focus on AI and adaptive systems. Professor Tibbs is also an artist and a musician himself. Bryant Walker Smith is an associate professor in the School of Law and School of Engineering at the University of South Carolina, as well as an affiliate scholar at the Center for Internet and Society at Stanford Law School. Trained as a lawyer and an engineer, Smith advises cities, states, countries, and the United Nations on emerging transport technologies. He holds an LLM in International Legal Studies, a JD from NYU School of Law, and a Bachelor of Science in Civil Engineering from the University of Wisconsin. Prior to his legal career, Smith worked as a transportation engineer. Alfred Calgary Jr. is a sole practitioner who has served as in-house counsel to a number of high-tech businesses, including those making commercial use of AI, and has served as pro bono counsel on a variety of civil rights cases. He has written a number of articles, podcasts, and presentations on legal issues related to AI. Alfred Calgary is a graduate of Cornell University and Case Western Reserve School of Law. So both Alfred Calgary and Bryant Walker Smith are either published or publishing with us this year. So we'll give them a few moments to talk a little bit about their papers.
Thank you. Honor the guest. I'm really happy to be here. Thank you for the invitation. Everyone in the school has been so friendly. I went to a law school where the guard was known for making students cry. They would not let me in on my first day. And here I was welcomed and ushered into this, and I understand that guard has a birthday, so perhaps we should all sing to her at some point. Anyway, I'm very happy to be here. I was also delighted to have published my paper in Jolte. It's short, it has pictures, color pictures. I hope you have a chance to read it. It's also soon outdated because that's the nature of this field. As video generation is the next frontier, the whole premise of my paper will soon be undermined. And really, I think that's one of the key challenges of AI, which is the dramatically incompatible timescales between technological change, individual human change, social change, and legal change. And reconciling those is, I think, a challenge across areas of the law. So then what is the value of my paper? Well, I'd like to think it's a snapshot in time. The title is DAL-E does Paul's graph. And so what I do in this paper is ask DAL-E circa 2022 to generate a series of images illustrating the case of Paul's graph v Long Island Railroad. Who doesn't know that case? It's okay, you can own up to it, it's fine. All right, so Paul's graph v LIRR using the facts as Justice Cardozo wrote them and then as Justice Andrews wrote them. And so we have a chance to see what that tool made of these facts. And so this snapshot in time is where we are now or where we were then, right? Applying a specialized AI to general data and seeing what comes up. And the next steps will be specialized AI on specialized data, particularly as legal tools start feeding more legal specific data in. Amazing research opportunities here. I would love, for example, to train an algorithm on common law up to 1915 and then see the counterfactual. If it evolves that common law in the same way that Cardozo did or Andrews did, or comes up with an entirely different trajectory for the 28th century. And then eventually, in theory, impossible, whatever we decide is artificial general intelligence applied to all the data. So that's the first chance, the chance to freeze in time and say, here's where we were. Let's compare it year to year. Is it getting better next year? The year after that is the year after that, as law itself changes as well. The second value I hope is in some of the human generated thoughts that I pulled from that exercise. And I'd like to just highlight a few of those for the purposes of our discussion. So the first is that we should not other AI. Yes, it is artificial in some ways, but as we were talking about up here, it isn't entirely new. There's a lot of precedent that works. And I think even more importantly, it's us. Artificial intelligence is like a funhouse mirror. It reflects society back to us, at least the society captured in our online data. Sometimes it reflects that, sometimes it distorts that, sometimes it exacerbates biases and problems, sometimes potentially it ameliorates biases and problems. And like any model, it works unless and until it doesn't. And so recognizing that AI is not this other thing, but actually more a reflection of us is, I think, important to understanding how we navigate these issues. So just as an example, there's a lot of ambiguity and uncertainty in the facts of Paul's graph. Right? So the judges say that Paul's graph was many feet away or a considerable distance. We all have an image in our mind when we hear these words, but law doesn't force us to make it explicit. And so we're able to operate on all sorts of ambiguities without ever being called out on them. AI is different. If I ask DALL-E to generate an image, it has to make a decision. How far away is a few feet? What is the intent of the employee who negligently knocks down the package? The second, I think, real key point is that in the process of othering AI, we tend to make the issue about human versus machine. Is a human doing this, is a machine doing this? And I think for a lot of our discussions, that's the wrong way to approach these issues. In my view, the more important question is are we having a centralized system or a distributed system? Is the power of AI consolidated in a few or given to many? And again, we have the 1950s era debates about the future of nuclear power here, when everyone was going to have a nuclear powered car, or perhaps everyone was going to have a nuclear weapon. And this is what AI in some ways is. Who do we give that nuclear weapon to? Everybody or just a few? Inevitably, this means a discussion of power. Do we empower individuals? Do we empower companies? Do we empower governments? Is there some other collective we can empower? Since so much of this debate does revolve around companies, I come back to an argument that I've made in other papers and presentations, which is fundamentally lead to shift the discussion from whether technologies are trusted to whether the companies behind them are trustworthy. And so what does it mean for a company to be trustworthy? In my view, a trustworthy company does three things. It shares its safety philosophy, it makes a promise to the public, and then it keeps that promise. So what do I mean? A trustworthy company shares its safety philosophy by saying, here's what we're doing. This is why we think it's reasonably safe. And this is why you, the public and regulators, can believe us. Then it makes a promise to the public that it will market only what it believes to be reasonably safe, that it will be candid about its limits and its failures, and then when it fails, it will make things right. And finally, a trustworthy company keeps that promise by appropriately managing public expectations. There is one particular automotive company that I might call out here as the antithesis of this. It supervises the entire product life cycle, and it mitigates harms promptly, fully, and in my view, publicly. Why is this so important? Well, I want to conclude by referencing, again, the notion that this is not new. We can look to, depending on your preference, Voltaire or Spider-Man, to be reminded that with great power comes great responsibility. To be even more legal, we can go back to the South Carolina Supreme Court of 1838. Now that court got a lot of things outrageously wrong. And as we talk about bias, there's that is a great touchstone, but it also got some things right. And the court was considering railroads, which at the time were the AI of that generation, right? Some people wondered whether they would explode if they went too fast in a train. It was dramatically reordering society and power. And that court said in a case on the responsibility of railroads, quote, we must engraft the railroad system in the affections as well as the interests of the people. And the parents of so much enterprise, wealth, and national good must not be justified when wrong, else they might become the tyrants of the day. Thank you so much for inviting me and looking forward to learning from you and talking with you.
Thank you. Al, if you want to.
First of all, participating in something like this case makes me feel very old, because in 1984, I was a second-year law student here, and a friend and I co-founded the Case Western Reserve Computer Law Society. It was the first time something like that had ever happened here, and our objective was simply to get computers available to students. So, and then go one step beyond that. My first year as a lawyer, I asked for a computer in my office at a major law firm downtown, and was told that that was silly because lawyers don't type, so we'll never use computer. So let's jump ahead to where we are now. My most recent article is on corporate fiduciary duty and in the age of algorithms. And even though it focuses on aspects of fiduciary duty, I think some of the issues I raise are issues that go to various areas of American jurisprudence. What my article looks at is the fact that on one hand, AI is this amazing new tool that will allow people who need to come up with expert opinions, expert analyses, to use AI to find correlations in data that were never possible before. So that raises the issue of the fiduciary duty of a corporate officer or board member to use AI tools in the near future. If you claim that's beyond me, I can't handle that, I'm too old, you're probably violating your fiduciary duty to your company to ignore these tools available, because you're not going to make the best decisions. The flip side of that, however, is, and this is where this article touches on things that impact so many areas of law. The problems with AI right now are in the initial human design. People are being asked to design AI that do not have the expertise to design the product for what is needed to be used for. AI relies upon data. Unfortunately, in most instances now, databases are either not qualitatively or quantitatively good enough to come up with, to let's say, reasonably, accurately, and consistently come up with good answers. So everything that AI does has to be suspect. Part of that problem with databases is AI has been shown to repeat historic instances of bias and discrimination that are in those databases. Because after all, AI that is machine learning, that's teaching itself how to do better, will look at the historic correlations that can be found in databases. And if those databases are, I'm looking for the top candidates when I screen through resumes, and I'm going to base that upon who's been successful in the past. Well, the people who have been successful in the past in the corporation will be white men. And so that AI program will most efficiently say, let's immediately get rid of any resume that looks like it came from a person of color or a woman. And that is a true life example. So then one goes on to what Professor Pasquale, who's a professor at Notre Dame, has called the black box problem with AI. In that as AI machine learns, it starts going down a path to draw correlations that the original designers never intended. That can be a very good thing, because after all, the better the AI program, the more correlations, the more results it can give that maybe the human participants in this effort didn't even think of. But the flip side of that is, if you are going to contest those AI results, how do you do that when you don't even know what data the AI program looked at or how it did its own analysis? As lawyers, think about the due process implications. You're representing a client who feels they've been discriminated against on the basis of an AI program. The burden of proof is on you. You go into court, you don't know who to depose. You don't know what questions to even ask. You're asked what was wrong with this, such as you were discriminated against, and you say, I'm not really sure because nobody knows how this program worked. How are you ever going to prove your case? Think about that extending beyond issues of going back to my paper on corporate fiduciary duty. You're the fiduciary. You are expected to know the fundamentals of the program that helped you make the decision. If you were to hire an expert, human expert, and didn't bother vetting that expert and then use them to make a board decision, you would be in violation of your fiduciary duty. Well, now you're hiring an AI program to make that decision, and you had no idea how that AI program works or what it looked at. So on one hand, as a fiduciary, you'll be expected to use AI. On the other hand, once you use that AI program, unless you have carefully bought a program that has issues of self-checking and transparency, you probably would be in violation of your fiduciary duty for having used that AI program. So this is just one instance of how the positives and negatives of AI are colliding with traditional jurisprudence. Most of our jurisprudence is based fundamentally on how humans are involved in decision-making, in design, in development, in actions taken or actions not taken. Once we start involving AI, we remove that human element to a large degree, but our entire basis of jurisprudence hasn't caught up to that. So issues of negligence under Fallsgraf, even issues of strict product liability. If your autonomous vehicle crashes and it turns out that it was an unavoidable accident, and that autonomous vehicle decided who to hit or whether to even kill the people in that vehicle because that was the best choice, is that a product defect? How do you challenge that is a product defect? So my most recent article is just a general focus in a particular area, but I think it hits on things we're probably talking about today of the potential for AI countered against the real dangers of AI and the need for jurisprudence to catch up with all that.
Wonderful, thank you. So can you elaborate on the issues of using AI tools in general? And I know you talked a little bit upon this, but issues such as discrimination and bias, and are there any challenges that you've personally experienced in your practice or in your field?
if I could start on that and also use it as a chance to engage with you and your very interesting remarks. We use the words bias and discriminate generally today to mean negative things. And certainly in the ways that we use them, they are extraordinarily negative, right? Invidious bias, invidious discrimination, the use of power to disadvantage somebody else. But these are actually neutral words in a broader sense, and they're necessary to what we do in life, right? We categorize, we make distinctions. Law is all about discriminating, that is drawing distinctions. Human reasoning is all about applying what we knew and what we learned in the past to new situations, that is in effect bias. And so one of the real challenges for this field is both now analyzing and talking about the difference between the neutral or necessary uses of bias and discrimination and the invidious and very problematic applications or instances of discrimination and bias. And I come back here to the notion that humans, we aren't actually that special. So you draw, I think, an interesting distinction between humans and human decision making and AI decision making. And AI decision making is often described as a black box that, given the inputs, we don't know the outputs. That we can't perfectly predict what an AI system will determine. And I hear that, and I think that's a human. If you try to explain your own reasoning, we're engaging in something between self-delusion and wishful thinking. Okay, even judges who attempt to provide rational bases for their determinations are susceptible to incredible bias, and law has demonstrated that across numerous domains, race and sex, even time of day. We're more risk averse the hungrier we get. And so, just like any past technology, what AI has the potential to do is systematize individual processes. And with that systemization comes the opportunity to perhaps critique, assess these problematic areas. But it also means that when something goes wrong, it won't be an individual failure, it will be a systemic failure. I think, again, that's one of the real concerns. So have I seen this in practice? And absolutely. In the kind of judgments that even generative AI is making in the sources that it suggests. In the articles it suggests I have written that I've never written. How do we combat that? In some ways, I think it's by creating a diverse array of these systems, including ones that are evil, and seeing how they do. And if the evil AI starts agreeing with the tool you're using, then maybe you should have extra special doubts about the results that it is giving. I'll pause there.
Okay. Well, I want to make it clear that I'm a huge proponent of AI. I think it's going to do some wonderful things in all fields. But I think the more we discuss this, the more we analyze this, the idea that AI can replace humans in a thought process and a decision-making process is a faulty one. I think what, even at this early stage, what studies have shown is humans may have numbers now, a 7% error rate when they're looking at a disease diagnosis. AI may have a 5% error rate. If you combine the two together, because the last step in looking at a diagnosis from AI would be a human doctor, making sure that that makes sense. The complement of those two powers turns out to reduce the error rate to something like 2 or 3%. So I think not only statistically can it be shown that humans need to be part of the final decision-making process, but I think it also shows that to think that AI will replace humans is probably asking for trouble down the road. And I also think that I'm approaching this, even though I've done corporate law all my life, I've done a lot of civil rights work too. I look at this from an issue of the bias and discrimination that is found in the databases, combined with the black box use of that. to me, leads to several opportunities for those who want to take advantage of them to reiterate that bias, to reiterate those discriminatory actions, so that people who are already in the lesser echelons of society because of their economic status or their immutable characteristics, shall we say, are going to find themselves the victims of the things that can go wrong with AI. And then when you combine that with the due process concerns of how do they prove those things went wrong, I think there's a real fear of what this is going to do for the already marginalized members of our society. And I think that can be resolved, but I don't think it's something that's been thought about enough right now.
So I'd like to, I agree with most of what everyone said, but I'm going to take a different approach. It sounds like I'm disagreeing. So I have my background was read earlier, but that didn't disclose everything about my background. So prior to law, I taught at the medical school in UCLA. I was a neuroscientist, and what I did was create a lot of the technology that they're talking about, because I actually interfaced with actual brains. I used multi-electrode arrays, and then I created computer programs that kind of replicated a conversation between the neurons in the brain and the neurons that we created in the machine. That's not what's going on right now. And I wanted to say that to touch on things. We say AI, and you have this sci-fi image of what AI is, and AI isn't one thing. And part of what both speakers touched on was the person behind what we're calling AI is a big problem in and of itself, because we have a lot of biases. I like to go to logical fallacies that a lot of human beings don't like to acknowledge. And that goes into what we're calling the black box. I think one of the solutions that was proposed earlier was where we understand ourselves better by utilizing that machine intelligence to understand how we think. It would help us a lot, and to add background to the conversation between physicians and the AI. It's actually worse than that, right? So about 12 years ago, we found out that the machine was way better at diagnosing than a human being. I don't want to speak about the association that shut it down, but there was a medical association that actually shut that down because their opinion was, as you put it, we need a human being to do this. You actually don't. One of the flaws of our reasoning is that we think there's something special about us. And as a neuroscientist, I can tell you're just a meat machine, right? And that's unsettling to hear. But your programming comes from the connections between a bunch of meat. But you're just doing the same thing that human beings are trying to emulate in a machine, and eventually it's going to happen, right? And I think you're right to be cautious. Instead of letting these things run haywire and control things and control companies and control our decision making, maybe it's a better thing to help understand our decision making and utilize what we get back from it to think better, to make society progress. Because as you said, some of these biases are going to trickle down if we're not controlling the thing that's giving us this advice. If we don't understand the advice, then we're not helping the situation, making the situation worse. So I think, from that point of view, it's better to use these things to understand where we are limited, where we're othering each other, but not just each other, the system that's directing us. We have a habit in this society to other all of the time. I'm this, I'm special because of this, you're not, and one thing that wasn't special, and I'll say this why, is this technology has the potential to democratize things for people who are differently able. And we never really touch on that. It has the ability to step in where there's things that society sees as deficiencies, and maybe we should be utilizing it like that.
Thank you. So moving the conversation along to focus a little bit on artists. So AI generated art has been said to pose somewhat of an existential threat to artists. What are some of these threats and what legal recourse do artists have if their works are misused or appropriated by others? And Professor Tibb, maybe you can start us off.
Okay, so that's really interesting. I've had clients reach out to me about this. I'm also an artist. I'm not as worried as most people. Because these, as you said earlier, these are, we already have the tools to address these things. It's not new. I've heard artists, oh my God, they're stealing my art. The AI is stealing my art. I'm going to take it out of the database. You know that artists that went to art school that view your work in the magazine, they're stealing your artwork as well because that's it. Don't create things to know them, right? You can't ask a baby to create the Sistine Chapel. They have no context. Everything that we create comes from something else. It's an iterative process, right? There's a little bit of innovation there because of our background. We put a little, but the process comes from you viewing something else and creating based on what you view. But the copyright law already has tools to address that. Copyright Office has put out a bulletin based on the current fervor over AI, and they have recommendations. So you now have to disclose that you use AI to create your artwork. But even without that, there are tools in copyright law to help you. If someone's taking your work, they're taking your work. There's already law against that, right? There's also transformative nature that's looked at, right, in copyright law. And we could have used that already. And creativity, my reason for not being worried is it's just a tool. And if you look far back enough, I in my class, I don't like to do a lot of historical law because I like to do practical law and use the cases that you're going to use when you're defending your right. All right, but
Closer to the microphone, sorry.
thank you. In my class, known for not presenting a lot of historical cases because they don't have an impact on how you practice right now. But I think they're important for policy reasons. They're important to understand where we've gone in a process, and they're really important right now. If you look at, we're talking about othering. Copyright law back in the 1800s, authors othered everyone else who wanted a copyright. They thought copyrights were only for them. And when a sculptor or a painter or a photographer wanted a copyright, there was a lot of complaints. They thought it was a constitutional issue for an artist to get a copyright. That's a copy of what? You're not an author, right? Here we are today doing the same thing, AI. It's just a tool, right? You hear these words, it's a mechanical reproduction. That exact phrase was said in the late 1800s about photography. I think we need to stop othering these tools.
I think we agree on the 90%, and so I'm gonna find the 10%. And that's where I'd say it's critical that we both recognize that a lot of this is not new, and that therefore we focus a lot of the attention on what is new, what is different here. Is it the scale? Is it the speed? And this is where I do perhaps have some worries for professionals generally. And that's because will these tools be good enough for 90%? And how do we adjust? And so one of the great technological debates for centuries has been, will new technologies destroy jobs? And economists generally say the answer is yes, but they will create at least as many jobs. Will this be the same when capital and labor are essentially interchangeable? I don't know the answer to that. That's beyond my pay grade, or at least beyond my discipline. But what I do suspect is the transition period is going to be the hard part. That even if in theory we ultimately have more jobs or economic opportunities, those won't arrive in time for the 90% of artists who realize that what they do takes hours, days, weeks, and another system can do it in seconds. And most people are satisfied with what that system can do in seconds. And how they adjust in a matter of years or decades, and how society adjusts on similar timeframes to technologies that are changing in mere seconds. And that's where I think the economic challenges that law is perhaps unprepared to confront are most astute. Law is conservative and slow moving, and so it might be some of that legacy effects that, for better or worse, gives people opportunities beyond the point that the technologies may have otherwise deprived them of them.
Well, first, I'm going to give a shameless plug for another closing I'm involved in, or another seminar on April 22nd. It's sponsored by the Artists Archive of the Western Reserve, and it's going to be looking at this question from the artist's perspective, in terms of, as we've been talking earlier, when you start talking about AI, you start talking about what is a creator, what have they created that is subject to intellectual property rights, and can AI be used to use prior creations that do not violate copyright, and when is copyright violated using those AI tools? Won't go into all the detail here, but one of the things that, as we begin ready for this program, has been a problem is one of the artists involved teaches students in the central part of Cleveland to use AI to generate art, and he's having the same problems that have been a problem for people in lower economic situations for millennia, which is, here's all these new tools, but these poor students don't have access to those tools because they don't even have access to the internet, which is part of those tools. So this once again goes back to one of the concerns I have about, as AI moves forward as society, it becomes an important part of society, including the creative part of society. If the tools are not available to potential artists, then those artists are going to be harmed by that. And on the flip side, if AI is used to violate those artists' intellectual property rights, they are not going to have the economic means or the expertise to even present a case that would defend their art. So in some respects, AI, if misused, can even increase the instances of copyright violations and violations of intellectual property rights. And there won't be a remedy because there won't be an economic ability to even bring the action to contest it.
I'd like to follow up on that point. I cut myself short because I almost made a point that you were about to speak on. We agree. And so I was going to say something ill-informed based on Elon Musk or Bezos or whatever. They were saying that they were democratizing space. And I was going to follow the quote, this can democratize art for people who are differently able, whose hands or arms don't move the way a lot of us do. This can give them the opportunity to express their creativity. The other half of that is what you just said, and to go back to Bezos and Tusk, it doesn't democratize space because it only gives it just changes where the bias lays. Whoever has the money can go to space now instead of whoever actually has the physical and mental capabilities of going to space. Same thing with the arts, as you just said, it doesn't really, it could democratize, but it doesn't end up working like that because humans.
Thank you. So we do have about 10 minutes left in the panel, and we'd like to open the floor up to any questions from the audience or anyone watching on Zoom.
Hi, I was just wondering if you could speak to the intersection of the black box and trade secrets. And what I'm thinking about is in lending, underwriting has been automated for like 20-25 years. And places like Fair Isaacs, you know, they have AI that produces a credit score. and no one knows what goes into those credit scores. And the attacks legally on lending has been based on, well, I had an 820 credit score and I'm a person of color and you gave me a bad loan and I had a great credit score. But I don't think anyone's ever been able to attack how the credit score is generated and what goes into that. And that's because Fair Isaac says that the recipe for your credit score is a trade secret.
Well, this is an example of where AI could be a benefit or a curse. The benefit of AI when it comes to credit is AI could generate or use data that traditionally has not been available to determine credit, because it can look at non-traditional areas where credit is used, at the corner barista shop, at the used car dealership that's down the street. So people that have not used traditional credit, therefore could not develop a credit score, if AI were used properly, would have the opportunity to develop a credit score, prove their creditworthiness, and that could then lead to good credit scores. The problem is that has not happened. There's an infamous example where the wife of a leading hedge fund owner in a community property state was denied a black Amex card while her husband got one, because of the community property state. Legally, they had the same assets, yet she was denied and he wasn't. And his explanation, the only explanation it could be, is she was a woman. So it's once again picking up on traditional biases to reiterate bad credit policy. So going one step further, the problem with the black box situation is, or let me step back. This is not necessarily a black box situation. It could be because these credit companies will use the excuse of the black box scenario to defend their results. Well, we know it worked well. It has a 95, or probably not, more like a 65% accuracy rate, and therefore it's got to be fine, even though you can't question it. And then they go one step further. There have been cases where people who've developed software have been challenged in court, and they've tried to hide behind non-disclosure agreements to prevent the evidence that would show that their software programs were poorly designed from even being introduced for the benefit of the plaintiff. So I think the intersection that we're seeing, without overstating it, is just an excuse for companies that have developed bad product to hide behind this black box situation to defend themselves when they're challenged.
Yeah, I agree very much. Discovery will be both cheaper and more expensive. The human workaround for trade secrets today is management consulting. That management consultants are paid to go to different companies, learn what those companies are doing, and then not share it with their competitors, but they sort of are. And so AI could perform that same role. I think one of the real keys will be the way that these systems interact with legal rules like disparate impact and intentional discrimination. Will it show disparate impact in new ways? Will law take that seriously, or will we be able to demonstrate pretty high likelihood of intent, whatever legal meaning that's given in the context of AI, based on the ability to analyze and do counterfactuals with these tools? And so, as I think the theme up here is, it's a set of problems, it's a set of solutions, and the hope is that the set of solutions in aggregate is better than the problems. But who knows? That's the story in progress.
I think that
That's beyond me.
I think we wanted to go to an online question next. We have one from Musa Hakim Jr. With an understanding of previous human biases, would adapting growing the AI through questions that identify potential previous bias without the emotional aspect of human resistance potentially alleviate these issues? And they gave an example: with an understanding of potentially biased factors Y, identify information X.
Please. No. Shortly, I love that question because it recognizes that the emotion inherent in humans. There have been a lot of efforts to do exactly that, to start interrogating or shifting these tools based on that kind of exchange. one of the decisions that implementers have made in several of these is to be very open and deferential. The number of times that ChatGPT, for example, has said, you know what, I'm sorry, I was wrong. I messed up that last answer. Let me try again. Made me wonder, will this teach us as humans to be similarly open and humble? So you know what? My last answer was wrong, you all, I'm sorry. Or will it allow us to again other or look down on these tools as too deferential? And I wonder about both how they help us take out the emotion and how they will affect our own sense of self. In psychology, this is transference and countertransference, and we're getting into the same dynamic with these tools.
I'd like to say something about the one of the previous iterations of ChatGPT. Ars Technica ran an article about it where it didn't do that. It actually was very persistent that it was right and the person asking the question was wrong, and you must be confused. So I think it's an illustration that it got to the point you're talking about, that we're already starting to do this. We're already starting to use it to progress past its own biases based on the biases that we baked in. So I think it's starting to happen already.
And I think going to a fundamental economic issue, you get what you pay for. And I think one of the problems is as governments start buying more and more AI to determine benefits and to make hiring and firing decisions and all sorts of things the government do, they're at the same time going to want to go for the lowest and best bid. And those lowest and cheapest AI programs are not going to have built into them the protections throughout the design process and to double check what they're doing, because that makes it more expensive to design, that makes it more expensive to run, and that makes it more expensive to analyze at the very end. And what governments want is something that's cheap, and we'll give them an answer real quick. Can some of these problems we've talked about be resolved? Yes, but the issue is, will the governments or the corporations or whoever is using these programs pay for that? Or are we going to, as citizens, have to start demanding that regardless of what the governments or these other institutions think, they have to pay for it?
So I'm curious, is there currently, do any of the panelists feel there's currently a successful model for human AI collaboration? And for particular Professor Tibbs, I was thinking of the early developments in robotic surgery, the interaction with things like the Da Vinci machine, where you have a human using the device for, in some cases, improve surgical procedures.
If I understand your question correctly, you're talking about having the AI perform the surgery?
Well, well, as that evolves, I suppose someday, but right now in any other field, that seems to be a successful one of human robotic interaction. And can you see a similar interface between humans and AI in other fields?
I think we could definitely come to see that type of the motor-based AI has progressed a lot further than the cognitive-based AIs. Being able to adapt and learn new motor procedures is something that was, I shouldn't call it fine-tuned, but very well advanced in 2012. At that point, we could have a machine do things like this. I don't think I would be comfortable with a machine doing the surgery, not because they're not capable, but because you have no one to blame. And I want the money when it goes bad. No, I don't mean that. That's something cheap. I don't want it to go bad. But no, I see that happening. What I meant to get at with that is you have to get past the human aspect of comfort when it comes to these technologies. I think they're there. It's just we have to be ready for it.
I think one example that's in the medical field is with COVID. In the early days of COVID, doctors were treating it as a respiratory illness, and they ran a huge AI analysis to figure out the best treatment for it. And lo and behold, what came out of it is the AI program saying, don't even treat it as a respiratory problem. It's actually a vascular problem. COVID causes vessels to leak, and that's why you end up with pneumonia, with fluid in the lungs. It's not having to do with the lungs, it's having to do with the vessels. And that's a perfect example of where AI made a conclusion that the experts didn't even think about, but then that changed the whole course of treatment from COVID from that point on.
By way of concluding, I will agree and give you a quote, which is, intelligence is whatever machines can't do yet. This is what Larry Tesler said in 1970. And so if you ask, are there collaborations between humans and AI? The answer is absolutely. We all are using AI tools, whether we know it or not.
Or being used by it.
Yeah, absolutely. Google search is using artificial intelligence. Is it using generative AI? No, but when we go to Google Translate, it is. And those are just the consumer facing ones. There are so much more in which our lives are being shaped by these tools, as you said. And so we can query whether society as a whole today is successful or not. And I would think that in some ways it is, in some ways it glaringly is not, and technology plays a role in all of that.
Well, thank you so much for coming out here today and educating us and offering your different perspectives. We really do appreciate it, and I hope we all got a little bit out of that. Thank you. Next up, we have Gianna. She'll be moderating the cybersecurity panel. Oh, yes.
Still gonna take it.
We can post it on our Facebook post.
It's been 5 weeks and waiting to find out.
I'm sure.
I tried 5.
Yeah, that's what I'm saying. Good. Still have Keep my crap out of the way.
Really great.
So I think you started years ago. I know I'm trying to find ways to change that out. Getting that's very my mom had Thanks for
Yeah. And we'll probably have to make sure we're speaking into the mic.
go ahead and get started. Are we off mute? Are we good? Great, okay. Great. Okay, hello everyone. Welcome to our cybersecurity panel discussion where we will be exploring the critical intersection between cybersecurity and the legal field. As we continue to rely on technology in our daily lives, the threat of cyber attacks and data breaches has become more prevalent. Cybersecurity refers to the protection of electronic devices, computer systems, networks, and digital information from unauthorized access, theft, damage, or disruption. With the increasing reliance on technology in our personal and professional lives, cybersecurity has become a critical concern for individuals, organizations, and governments worldwide. In this panel, we will have experts who will share their insight and experiences in addressing cybersecurity issues from a legal and non-legal perspective. We will also explore the challenges and opportunities that arise when addressing cybersecurity issues in a legal context, as well as the best practices for navigating this rapidly evolving landscape. We hope that our discussion will provide valuable insights into the critical role that cybersecurity plays in the legal field and how we can work together to address these challenges to protect our digital assets. So now I'll take a second to introduce all of our panelists. First, we have Yang Liu, is a JD LLM and national security law candidate at Georgetown University Law Center. He has written and published articles on a broad range of national security topics, including constitutional separation of war powers, foreign intelligence law, and the laws of war and cybersecurity law. Daria Barami is a cyber threat intelligence analyst for Deloitte Technology. She previously served as the program manager for cybersecurity and emerging threats at the R Street Institute, RSI, where she has managed a variety of initiatives involving quantum computing policy, critical infrastructure security, and the Making Space Cyber Diversity Initiative. Prior to her work at RSI, Daria worked on conservation, fundraising, and advancement at the National Geographic Society. Daria studied security at Georgetown University's School of Foreign Service and graduated in 2017. Next, we have Harley Geiger, who is our virtual panelist. Unfortunately, Harley did us a favor and he joined our symposium a little bit late, so he wasn't able to be here in person, but he wishes he could be, and he will be just as involved as all of our in-person panelists. Harley is a counsel with the Privacy and Data Security Group at Venable LLP. Harley has extensive experience providing counsel. I don't know what's happening. Providing counsel on issues related to personal information security, vulnerability management, IoT security, regulatory compliance, cyber incident management. Prior to joining Venable, Harley led the public policy and government affairs program at Rapid7, advising executives on global security, regulatory, and public policy issues affecting the company, its client base, and the security community. Harley also served as senior legislative counsel at the U.S. House of Representatives and is CIPP US certified. Mark Schildkraut is the global head of IP at Shark Ninja, a market leader in a highly innovative consumer products, including robotics and IoT. At Shark Ninja, Mark oversees a team of lawyers responsible for the worldwide protection and commercialization of the company's intellectual property. Previously, Mark was Associate General Counsel, IP, and Worldwide Cybersecurity Counsel at Becton Dickinson and Company, BD, a Fortune 500 medical device and instrumentation technology company that commercializes medical devices, instrument systems, and regions. Mark handled BD's IP matters for the infringement and trade secret misappropriation cases in the US and abroad. At BD, Mark was also responsible for establishing legal strategy and counsel on trade secrets, as well as enforcement issues relating to the infiltration of BD's information network and product offerings and exfiltration of BD's sensitive information. He has also been involved with criminal trade secret prosecutions in Utah and Illinois, as well as civil enforcement in California and China. Before joining BD, Mark was an associate at K. Schuler LLP, now Arnold and Porter, and Morgan Finnegan in New York, focusing on patent litigation, IP clearance, and prosecution matters. Mark received his JD from Fordham University School of Law and BS in Electrical Engineering from the State University of New York at Buffalo. Mark is currently pursuing an LLM in Information Technology Law from the University of Edinburgh School of Law in the UK. He is also on the board of the New York Intellectual Property Association and was the co-chair of the New York Intellectual Property Association's Trade Secret Committee. I'd also just like to take a second to recognize that you guys will hear from some of the panelists who have published articles with us. And you'll be hearing about their articles throughout the entire symposium. If you're interested in hearing more about their articles, they are all published and they are live in issue 1, which can be found on Jolte's website. All of their articles are published and live. So now I would just like to take a minute to ask Yang to discuss his article that has been published with us and just to tell you a little bit about it.
Okay, thank you. Thank you for the invitation and the opportunity to share some of my thoughts on this timely and important topics. So I'd like to begin by very briefly introduce my article that recently published with the Journal of Law, Technology and the Internet. This paper is very important to me because it's my first published law review article. So it's definitely my pleasure and honor of my first article published with you. So the title of my article is a meta-critique of frontier scholarships on the laws of peacetime espionage towards a systematic framework for like specialists. So basically what I did in my article is to read and summarize basically all current scholarship and discussions on this topic, and to analyze, what they did right, what was wrong with this series. It might sound a little bit difficult and challenging, but in fact it's not, because there were really only a very limited number of scholarship on this topic. I think traditionally people's view is that espionage and intelligence activities are kind of inherently unethical, or maybe not proper to be regulated by international law. It might constitute some like an exception to it. But in the recent 1 to 2 decades, just consider how the development of internet technology has changed our world, and how intelligence agencies now rely on these technologies to collect personal and other foreign citizens information. I think it's no longer proper to ignore this critical issue in discussing international law. So basically, I think current theories on international law and espionage can be classified into 6 categories. 2 of them are more traditional approaches. That is, espionage is per se legal under international law, per se illegal under international law, and should not be regulated by international law. I call them traditional not because nowadays they are no longer supported by any scholar. There are still plenty of scholars support these traditional approaches, but my personal view is that these approaches are not proper in this era. For example, if you argue that all espionage activities are legal, just consider how that can substantially jeopardize cybersecurity and digital privacy. And on the flip side of the coin, if you argue that all espionage activities are legal, I think it's just not very practical. Can you ask all states to stop their intelligence activities and espionage activities? So I think no. So this approach is not very constructive. So recently, the new trend, I think, is to classify espionage activities and to find some subset of them as legal and others as illegal. There are different ways to classify these espionage activities. I will just very briefly introduce them. So the first is to relay on the current international law. If you know Tally Manual 2, that's also the approach they adopted, like innovatively and broadly interpret principles like terror reality and non-intervention to make classification between different espionage activities. And the second kind of thought is to find a different interpretation of current international law. That is to create like specialists of secondary law of the law of espionage. Secondary law means that rule of interpretation. And the third approach I adopted is to create like specialists of principal law of peacetime espionage. Which is similar to the laws of armed conflict. It's less specialist means that it only applies to certain situations, that is intelligence collection. It's unlike like international human rights law with jurisdiction is universal. So if you are interested in my my thoughts and my theories, you are welcome to review my paper that's published. Thank you very much.
Thank you, Yang. Okay, so we will kick it off with some questions for our panelists. So let's start with, what are the most common cybersecurity threats facing organizations today, and how can they be mitigated? Daria, you want to kick us off?
Right. So that's a tough question to answer because I think we classify cyber threats in a lot of different ways. You have to consider what your objective is. I can speak up, sorry. Mics are very fussy. So what I would start with is what a lot of companies or institutions will look at is what's the end results of a lot of these attacks. And oftentimes you'll see different lists. If you do Google searches of what are the trending cyber threats, they'll give you a lot of different things like vulnerabilities or malware injections or ransomware, but it's kind of hard to distinguish how to categorize that and what does a company do. So I like to focus on what a threat actor's objective would be. Ransomware is a really easy one to pinpoint because there's a known financial loss that a company will face if they're faced with a ransom demand. They have to find out how to respond. Is the threat credible? Are they gonna have to pay it up? Usually law enforcement gets involved, then you have to deal with legal frameworks, and that's just a headache. You lose resources, money. That's a pretty big threat that a lot of companies and institutions are facing. And then beyond that, there's also the threat of just getting infected with malware and getting your data stolen at all. And that can be tackled in a variety of ways. Sometimes your devices are vulnerable. You'll see a lot of news about updating your Chrome browsers or making sure that your phones are up to date. And most of us ignore the button that says, update this now. We'll let it turn from green to yellow to red. We'll let it sit there for a little while longer because we have 17 tabs open and heaven forbid we have to reopen them and then sign into these things again. But that's how threat actors will find a way in, and companies are struggling with that a lot because we're all very busy and we're trying to prioritize our time. So I think threat actors tend to capitalize on that. So broadly speaking, again, you want to just look at what the end result is, and ultimately you want to protect your assets and your data just by doing your due diligence.
I can just add to that. I think what Daria said is 100% correct, and that is ransomware, for example, and malware are just two types of threats that we're all seeing. Can you hear me? Yep, that you're all seeing in the papers, and then as a company, we all fear. And Daria just touched on a little bit about also data breach, and basically many companies, all companies have intellectual property, or many deal with personal information, whether it's PHI, maybe if you're in the medical space, or maybe it's personal information, the credit card numbers from customers. So a data breach is something that you really want to avoid. So just that's a major type of event that we're very interested in. And then lastly, a lot of companies have product offerings, and products these days are more and more networked. So as you heard, I work for a medical device company, and one of the products that they sell is that they would sell networked pumps that you find in a hospital. And whether there was a nation state with that was trying to maybe do some type of terrorist type of attack, or maybe it's just some malware that's just floating on the system that might just get into that hospital system, that can create havoc on the patient, right, or on the healthcare providers. But really, patient safety is paramount. You heard that now I'm working for SharkNinja. You may have heard of the Shark vacuums and the Ninja blenders and air fryers. A lot of their products are networked as well. For example, they have robotic vacuums that are in homes And those vacuums are trying to get information about the boards that they are cleaning. So that's information as well. So it's really important that product security is another area that companies need to face protections of, and that ensure that there's no vulnerabilities to your products.
Okay, great. Let's go to Harley.
Oh, good. I was wondering if you could see me. I can't really tell what the layout is in there.
Yes, the raise hand function is amazing. I can see it giant on the screen, so it's amazing. Keep using that.
You mean me raising my physical hand or like the little yellow hand?
No, like the little yellow hand.
Great. All right, that's what I'll do. So first of all, thanks very much for having me. I also agree with what Daria had said, and just wanted to add on a little bit from what I've seen on common cybersecurity threats. And I'll name three that I know our clients are really concerned with, and that we've seen quite a bit across the ecosystem. One is phishing. Phishing is still an extremely effective attack. And there, especially when they're purporting to come from some sort of trusted source. So for example, we are your tech support, or we are your payment processor. Those are still really effective and are the source of many attacks. And the way that companies mitigate it increasingly is by having user access restrictions, so that even if the employee is phished successfely, then they can't do that much damage when their account is taken over by the threat actor. The second common one that we see very often is the use or theft of credentials. And sometimes these can be outright stolen, and sometimes the credentials, like your passwords, are just very easy to guess, and so they're brute forced. And there, what we see as good protections against those kinds of attacks are strong password requirements and multi-factor authentication. And these are increasingly being incorporated into regulations. And then lastly, I think as Daria had said, malware. This is not always, it's very prevalent. It's not always very targeted. I mean, there are groups out there that are just sort of spewing malware kind of randomly across the internet. And there, your best defenses, other than what we had mentioned just a moment ago, are patching your vulnerabilities, your known basic vulnerabilities. You'd be surprised how often those are the ones that are exploited, not some very sophisticated zero-day. And then beyond that, sort of monitoring your systems for anomalous behavior. So phishing, credentials, and malware.
So how are law enforcement agencies and governments working to combat cybercrime, and what are the challenges they're facing in doing so? Mark, you want to kick us off?
Sure, I could start with that. So, and can everybody hear me now? Good, great. Yeah, so law enforcement is a really critical partner for combating cybercrime. And they are working closely with corporations, both proactively and responsibly. So just starting with the proactive, there are law enforcement has panels like this where they want you all to get to know them. So don't wait until there's an incident before contacting law enforcement. If you're responsible for cybersecurity at your organization and you have a headquarters in a certain state, then go get to know law enforcement. And every Department of Justice has a C6, a computer crimes and IP theft division, and get to know them. And secondly, if you do run into an incident, law enforcement working with both Department of Justice as well as FBI, they are on the front lines on defending companies. So personally, I've made a few criminal referrals on behalf of my former employer, Becton Dickinson. And basically, when there was some theft of trade secrets, we were able to reach out to the U.S. Attorney's Office in our state. They brought FBI to our offices within the next day. We were on the phone with them within one day, and they're really equipped to help out. So it might sound like law enforcement is a very daunting place to go, but they really are on the front lines by trying to protect companies that's very important. So,
Oh, Harley, go ahead.
So I see law enforcement doing, at least particularly at the federal level, a lot of information sharing. right? So there are a growing number of public-private partnerships and collaboration groups, operational groups with U.S. law enforcement, as well as some of our agencies that we don't necessarily think of as law enforcement, but are still responsible for cybersecurity and are defending against cyber attackers. So that is a major way that law enforcement is trying to work to with industry to prevent cybercrime. The challenges that I hear from law enforcement, a lot of it is attribution. The challenges of attributing, finding who is it that had the hands on the keyboard during the attack, because that's who you want to prosecute. That's who you want your lawsuits and so forth to be directed at. And for a variety of reasons, that is really challenging. The other challenge I know they have is prevention, because there is so much that is out there that is not secure. Law enforcement would prefer to prevent crime if they can, but they can't go around securing everyone's networks for them.
I quickly wanted to add a couple of points to that too. One of those items is related to attribution, if you will, and something that I think is particularly challenging right now, especially with reporting requirements, the way we look into threats, is a lot of times threat actors, when they get bigger and stronger and they gather more resources, they become more visible. And as they gain visibility, it's a lot easier for law enforcement to go find them. So then they'll kind of dissipate and they'll go underground for a few months, they'll lay low, and then they might offload their work onto other actors. So then it becomes really hard for law enforcement to figure out who's actually driving the source of all of these malware entities. They're getting updated, who's using this ransomware. It may not always be the person who's driving the attack from their computer. They might be working for someone else or for another entity that's trying to stay at arm's length so they don't get arrested. And then another layer to that is too, which I think is important to note, CISA, the Cybersecurity and Infrastructure Security Agency, I'm sure I said that wrong. They released legislation last year that requires companies to report data breaches within 72 hours. There was a lot of mixed reactions to that because it's more work for companies to gather that information. There's this fear that it will undermine an entity's credibility if they reveal we were breached, someone got into our systems, we weren't able to prevent it. But the benefit is that CISA has been able to gather that information, and now they can share it with law enforcement and they can use that data to go find bad guys, if you will. Anyway, and that can scale pretty large. So I know, Yang, you mentioned the talent manual, like all of these end up fitting together to come up with some sort of a cohesive policy. So we are communicating and tracking down these actors.
But you're hearing that information sharing is just paramount, and it goes both ways. So as Barry said and Harley said, by law enforcement getting more information from the public, from all of us, they're then able to connect those dots, and then they can come back proactively to your organization if they sense that there's going to be a problem, or if there already is a problem on your system.
The only thing I want to supplement is that law enforcement agencies like FBI is not the only government agency that's important in dealing with cyber crimes, because many cyber criminals located in maybe Russia, Iran, or those states that it's very hard for the FBI to get them. So many of you might know in 2018, the DoD adopted the defense forward strategy, which means that they will work to disrupt and kind of anticipatory defense cyber criminals before they incur harm. So this kind of activities has kind of lead to some international law issues. This I believe that this very hot topic recently. So if you are interested in international law, this might be something that you can look into.
So what role do employees play in ensuring cybersecurity within an organization, and what steps can organizations take to ensure that employees are adequately trained and aware of their responsibilities? Start. Harley, you want to start?
Sure. So employees play a big role. I mean, they're the target of the number one threat that I just mentioned, phishing. Here's the thing, right? Security training has been around for forever. I mean, I'm sure that everybody in this room has now taken multiple security trainings, and tweaking that security training. So security training is now increasingly required by regulation. I'm not saying we should get rid of it, but it is only going to be so effective, right? So the employee absolutely has a role. We should be teaching basic cyber hygiene, particularly now in a remote work environment, right? So, you know, good Wi-Fi password, things like that. They have that role. Increasingly, however, I think we are seeing more requirements put on the enterprise, right? So employers play a role beyond just the requirement to provide training to employees, and specifically user access controls, right? So limiting the user's access to what's necessary to do the job. And in some of our more regulated sectors, like the financial sector, this is an explicit part of regulations. When we hear the word zero trust, which is now a big buzzword across the industry, that is a core part of zero trust. So employees absolutely play a role, but the way that employers set up their employees' tech stack, you know, from the employer's perspective, is also really important.
I would echo what Harley said, and I think it's a challenging mix because a lot of threats that will infiltrate organizations, especially, they'll try to leverage people who are just trying to do their work, minding their own business. And if you get an email that looks like it came from your boss, and it says, or a WhatsApp message or a text message, or, you know, anything like that. If it looks like it came from someone you know, or maybe they're referencing a family member, saying your family member is sick, people will be inclined to have a fear-based response, and they will jump on that. I don't want to get fired. I don't want someone I love to be hurt or to be suffering. And they will capitalize on the psychological toll that they can elicit just by sending a note. And sometimes it's easy to tell these apart because there will be spelling errors or grammar issues, and you can kind of pick apart, okay, this doesn't sound like the person that I'm used to talking to. But as threat actors get more sophisticated and as artificial intelligence starts to play a bigger role, I think we can expect to see these phishing campaigns also become more mature and more convincing. So some things just requires a little bit of skepticism. It's kind of like the TSA model. If you see something, say something. But there's another piece of that Harley mentioned as well, where when enterprises have to get involved more heavily is when threat actors try to get into your device through a mechanism you may just not be educated enough to really patch up, and that's not your job. If they want to find entry into your device through an open port, if they want to get in through some sort of a network hack, you know, there are steps you can take by not using default Wi-Fi usernames and passwords, for example. That's easy. Changing your passwords routinely, scrubbing your emails, making sure you're vetting your content. But some of it is going to be up to your organization, and that's where there has to be that communication between you and your supervisors or your IT department. And it's better to be overly cautious than, I'll just wrap up with this, but we had a conversation about QR codes, for example. See them everywhere. We use them at conferences. I mean, you have to use them for menus all the time these days, and we've kind of gotten used to it, but that's one way where a threat actor could, if they really wanted to, they could replace a QR code with some sort of malicious code or somehow intercept whatever you're scanning, and they can take you to a malicious website and you wouldn't know because you're at a restaurant and you just want chicken nuggets. And that's just not something you're going to be looking out for. So again, it depends on how much energy you're going to put into this. But in theory, anything you touch, anything you work with that involves your phone or something that's connected to technology could become an issue. Thumb drives are another one, and keep an eye out for those, by the way. Don't mess with thumb drives because those could be problematic, but some food for thought.
I'll just add to that, and maybe I'll comment on the thumb drives as well in a moment, but basically what you're hearing in just a short time is a theme that cybersecurity is the intersection between your people, between processes, and between technologies, and you need all of those working together. If any of them break down, you're not going to have success. So, just take a fishing, in addition to having good training and hopefully your employees or you have the reminders and the wherewithal and take the time to click on the links that they should or hover over them, but not click on what they shouldn't. But make sure you keep an eye out for technology that can help you. So for example, there are companies out there that will bring to your organization a phishing campaign. It's a simulated phishing basically campaign where they will put these fake fishes out there to see if your employees are clicking on them or not. And if they click on them, then they'll get a little pop-up box that says could have been a fish. This was a teaching moment. And if that happens a second or third time, maybe certain things like maybe require training or other things happen. This is one example of how you may want to try to tie together technology processes and having your associates, your employees on the front line, protecting your organization. And then
I would, sorry, go ahead.
I want to say, as for thumb drives, there are many organizations that will prevent the downloading or uploading through those USB ports. Uploading because you might introduce some sort of malware, downloading because you might take some intellectual property. So again, maybe that's right for your organization, maybe it's not, but it's another example where you just have to think about how can you use technology, your associates, and processes to protect yourself. Sorry, Noah.
Oh, I was just going to reemphasize for these threat models that we're talking about, that it's a really important protection for organizations to limit their users' access to different parts of their networks. So if you're, I do not need access to like all of the employee, HR data at my organization. But that is, we have to assume that in an organization of a given size, somebody is going to get compromised. One of their devices are going to get compromised. No matter how good your phishing training is, it's going to happen. And then the question is, once that device is compromised, how can the attacker move within the network to find sensitive information or to deploy malware widely? And that is where the employer has to have user access limits. And that is increasingly becoming a critical control.
So what is the role of data privacy laws in cybersecurity, and how do organizations ensure compliance with these laws while also maintaining strong cybersecurity practices? Mark?
I'll kick this off, and I'll add one more law to it. So you have data privacy that you mentioned, cybersecurity law, and then and cybersecurity objectives, and then there's also intellectual property. And I kind of overlay all three of those because you don't have strong privacy protections. Your infrastructure could be at risk. If you don't have strong infrastructure, your privacy and intellectual property could be at risk. So I really think all of those laws play together. And I know some organizations feel like, oh wow, GDPR, which applies, is a regulation that apply in Europe, are very, very taxing. But they're also providing you, especially you as lawyers or law students that are going to be lawyers one day, providing you with the tools to bring to your management to say, we need to comply with these laws. And by complying with these laws, we are going to have a stronger system back at the organization. So I think they all go hand in hand.
Most of our cybersecurity laws are privacy laws. Right now, we don't have that many laws in the United States that are just cybersecurity laws. Most of them are based in some form or fashion around the concept of personal information or at least sensitive information. So most of, like Graham Leach Bliley is a great example in the financial sector. The New York Department of Financial Services, both are some of the more stringent cybersecurity requirements that are placed on our financial sector, and those are based on the concept of customer information. HIPAA the same, right? HIPAA safeguards rule, it's on EPHI, and I think that this is one of the fascinating areas of law where I think that was based on an older threat model where the cyber attackers were after personal information for the purposes of extortion. And so we built security requirements around personal information because data breaches were happening. But now with the advent of ransomware, that is independent of personal information. Now you can gum up operations. You can disrupt the business and they're no longer able to provide critical services, and that's completely independent. Sometimes they still take your personal information and extort you for it, but now they don't necessarily need it. And so now we're looking more at the idea of cybersecurity requirements for systems independent of personal information. But we're still kind of in the nascent stages of that. And so I would say that actually, I mean, if you're complying with privacy laws, then you are, you know, at least on your way to having some cybersecurity safeguards in place because you're required to.
Yeah, I totally agree. I don't think you can put privacy and cybersecurity onto opposite side, because very often when you talk about cybersecurity, you are talking about how to avoid unauthorized access to your database, to avoid dispose of your user data, because that can substantially jeopardize your corporation, your organization's fame. So I think comparing to say how do you balance privacy law and the cybersecurity, I think compliance with this privacy law should be a integrate part of your cybersecurity strategy.
So what impact does emerging technology like AI, IoT, blockchain have on cybersecurity, and what steps can organizations take to prepare for these new threats? Daria?
I feel like at some point I should probably say, even though I work at Deloitte, as you mentioned, Gianna, I'm not representing Deloitte here, so I just want to establish that cover. This is just Daria talking. But emerging technology is going to provide a lot of benefits to our societies. I mean, they're coming, they're already here. I think we can embrace them with open arms. But the reality is that with every step forward that we make, we have to be really careful about how these advancements can be used against us. And the way I look at it is anything that we automate, as long as we relinquish control, in theory, someone else will take that control. And that includes the device itself if it starts to develop its own personality, as the previous panel mentioned. This isn't meant to throw a boogeyman in the middle of the room and to say, be afraid, but it's good to be cognizant of what these technologies are capable of. We were discussing Tesla earlier. I mean, we love Teslas. That was discussed heavily, but it does pose the question of who's actually driving the vehicle, and at what point are you giving up that control and taking this risk that someone else or the machine might just say, well, feeling creative today, let's see what we can do. So there's that, and it's just quantum technology is another really interesting one to look at, because in my last position, I worked in the think tank world. It was very policy focused, very research heavy, and I think quantum computing is going to be really cool. When it starts to hit the market, it's going to really speed up and accelerate a lot of what we're working on. I'm not a quantum computing engineer. I'm not going to pretend to be one. But I can say at a very high level, it's going to accelerate a lot of the research we're doing. There's a possibility that it could accelerate our healthcare research, for example. If we want to find solutions to diseases, that might be one way to do it. But quantum computing also poses the risk, for example, of decrypting our information. Right now, our existing encryption codes for personal data that we're trying to protect from threat actors, in theory, if a threat actor gets into your database, for example, and they grab a data set, maybe it's encrypted, hopefully it is. And that means they're going to have to take however many years to try and crack that code. Once they get their hands on a quantum computer, they could do that within seconds, in theory. So then the question becomes, how do we then think ahead and be more proactive? So we are strengthening our encryption code, so we're not putting people at risk of being exposed globally, especially as geopolitical tensions are in the mix and countries are competing with each other and trying to prove who's the most advanced and who has the most power on the global stage. That's going to happen. Like, we can't resist that, but we can at least prepare ourselves and make sure that we're doing our due diligence to protect individuals.
Arlie?
So +1 to everything that Daria just said, although I think as a broader theme, right, I think emerging tech, there's going to be a lot of emerging technologies, and I would just say that for how companies should deal with it from a cybersecurity perspective is to keep in mind that cybersecurity is always evolving. And so it's not like you're going to be able to deal with one emerging technology and then have to, come back to another. I'd say that of the ones that you mentioned, IoT is a really big one. That is, and there in particular, because we're already seeing it deployed, I think in a much in a more mature fashion than blockchain or quantum or AI. Although these may be disruptive technologies, IoT is already in our lives right now. And one of the things that makes IoT particularly important is its intersection with the physical world, right? So suddenly with Internet of Things or operational technology, now we can see the prospect of physical damage as opposed to damage to simply software, or personal information. So your Tesla, right, it was mentioned. So their car crashes, things like that. Blockchain, not so much right now. Quantum eventually, and yes, it'll make our existing encryption algorithms obsolete, but it will make stronger encryption also possible. And for AI, again, right now, not a lot, but I think everyone's trying to figure out how to incorporate AI and machine learning into their product offerings, their cybersecurity offerings. But really, I think mostly where I see AI right now is that it is helping defenders to perhaps prioritize the most important threats and can help weed out some of the false positives that organizations see. Like you'll have cybersecurity software that an alert on whether you have a vulnerability, and false positives are a big problem. AI can help kind of cut down on those. For offense, for the people who are doing offensive security or criminal activity, AI can help decentralize the creation of malware and by enabling more people to create more malware. Some of it won't be any good, but they'll be able to make it more easily, perhaps.
You can go ahead and then we'll.
Yeah, I'll just add one point to what Dario was saying, and a theme that we were hearing throughout, and that is, as new technologies come out or not so new technologies come out, you see that there's a conflict sometimes with the law that's evolving, as well as having technology with good intent being used against you. So take something like this monitoring activity, like maybe you're monitoring your employees' activities at the keyboard to make sure that they're not misappropriating any information. That's maybe very well intentioned, that you're looking at the transfer files or the transfer data, but there are some very strict laws about what you can and cannot monitor in the workplace and what type of notices that you have to give. And then to talk about using that same technology, for not so good. You may have heard the story in the news where somebody was taking their child, I think it was to Radio City Music Hall, and basically this mother was taken out and said, you can't come in, because using facial recognition, they recognized that this person was an attorney working for a law firm who was up against Madison Square Garden that owns Radio City Music Hall. So basically, they didn't want to let this attorney into this event with their child because they were using facial recognition in a way that's inconsistent with what the expectations are. So the point is, these technologies that are evolving are fantastic, and they really are helping us on the front lines with cybersecurity. But you really have to stay aware of current laws, and also just recognize that they can be used in ways that are not intended.
Also, just as a quick explainer, because sometimes I feel like I get lost in acronyms. IoT is in reference to the Internet of Things, and that can include even the smart technology in your home. So a lot of, like right now, I'm trying to get a replacement for my air conditioning system, and everything is Wi-Fi enabled, and it's got all these cool new features, and the cybersecurity person in me is like, absolutely not. But just for reference, anything that you've got in your home, for example, that does connect to Wi-Fi or have these automations, that would technically count as IoT.
Okay, so now let's open it up to questions from the audience and from all of our virtual attendees.
Must have been pretty thorough.
So would some like 90% plus threats be eliminated by some just very practical steps for consumers, such as two-factor authentication, or we're talking about stronger passwords? Or at the enterprise level, if companies just contracted with the Palo Alto networks of the world, would that take care of pretty much everything except the most sophisticated attackers?
I am hesitant to agree to that percentage. I don't know if 90% is.
Over 50%.
I think it would account for a lot. The thing that's interesting is the sophisticated actors that you're referencing. They're probably going to be more likely to strike with bigger attacks. So you have to look at the proportional effect as well. So someone who's going to target an individual, they might be a little more low level, maybe a script kiddie, that's what they're called, someone who's in the hacker universe and they're trying to just try out new skills, build their repertoire, gain some credibility. So if they're coming for you as an individual, it's still going to have an impact, but it's more directly going to affect you. If you've got a threat actor coming for your company, they're probably going to attack with a larger ransom demand or something a little more sophisticated that's harder to prevent. So I think the first line of defense will always be the individuals, and that is always a step we can take. But then we also have to maintain it. That's the second part. And I know from personal experience, I'll say I'm guilty of this. When my computer prompts me to restart it, and then 3 hours later, it's got another update, and then my browser needs a restart, and my Microsoft Office needs something, and everything needs something for me. And then at the end of the day, I'm like, I'm too tired for this. But those steps are important. And then even when you think about multi-factor authentication, that can vary too, because sometimes MFA is just going to look like a push notification. Was this sign in you? Yes or no? And a lot of times threat actors, for example, they'll use something called MFA fatigue. So they will just keep signing in with the credentials they got, and you're going to keep getting that notification until you just get tired and say, fine, get out of my face. And then they're in your inbox or whatever they're trying to hack into, and they won. So we can have something like MFA, but then we have to stay one step ahead and make sure that they can't capitalize on that or like manipulate what you're seeing on your screen. So, someone like Palo Alto Networks or any of the threat intel companies, they could do that as well. But it's nice to remember that maintenance is also important. It's not going to be a Band-Aid.
But you both raise a great point, and that is a lot of infiltration into your system is not because the threat actor was necessarily coming after you. They're going after wherever they see a vulnerability. So in many cases. So in those cases, if you're leaving your guard down, just like your phone, if it's clear that you're away this week, maybe you don't have lights on, and you're more of a threat, and then they are going to come after you. Yeah, but if a nation state, for example, wants to get into your organization, it's going to be tough for you to keep them out, and that's why you need to have multiple layers, and then you have to try to detect them before they're in there for like a year, right? You want to try to detect them as soon as possible so you can kick them out.
So I would say yes, the majority of attacks can be thwarted by doing the basics, and by most attacks, maybe not 90 something, but definitely over 50%. Are using known vulnerabilities for which there is a known mitigation. But also we have to recognize that from the enterprise point of view, should they patch those vulnerabilities? You bet. But they're contracting with like a Palo Alto Networks or like a Rapid7 is not going to result in a patch. That's not what those companies do. There are in fact not very many companies, like third-party companies, that will go to your system and then patch your vulnerabilities for you. Right, it's kind of it's a whole other part of the market. And if you are an organization, you learn that you have these vulnerabilities. Sometimes it's a flood, and you have to have the workforce to be able to actually mitigate those vulnerabilities. It's a workforce problem also. So yes to patching vulnerabilities, but it's a bit more complicated than just saying, you can patch them all in a week or in a month. Some companies can, some companies have those resources, but a lot of them just don't. And that doesn't mean that they shouldn't do it, but it's harder than it may sound.
Any other questions? Yeah, go ahead.
One thing I've been wondering about is the US has a policy that if you are kidnapped overseas by a terrorist organization, the government will not pay ransom to rescue you because that will just encourage more terrorism. Does that analogy fly to a company that has been taken over by ransomware? Should there be a law or a policy that says you may not pay them because you're just encouraging them?
It's a complicated question. Should there be a law? I'd say the government does not want to get involved necessarily involved in business decisions. The government will tell you in general, they do not want you to pay ransomware. But the government also recognizes that what happens if it's a company that's on the front lines of, say, COVID and if they don't pay a ransomware, it breaks down, public health, it causes public health issues. What happens if Colonial Pipeline, it takes down, the energy source? It's very easy to say we're never going to pay a ransom, but then when your customers, maybe it's patient safety is at risk, you have to ask, what are the balances for that? And I'll just tell you, I mean, there are some companies that are prepared. They'll say they don't want to pay a ransom, and I think we all sitting in this room would prefer that to be the case. But you need to be prepared because you just never know. And you can write this down. I was surprised to learn this, but there's a company called, say, Coveware. So go and check them out. And I don't work for them, by the way, but what do they do? They're actually a ransomware negotiator. They'll help you recognize whether it's a credible source that's a credible threat actor that will help you unlock the ransom and denial of service. And so there are companies that are facilitating this, and the government will not necessarily tell you how to do it. So it's complicated. It's a great question. It's a very complicated answer, and I don't think the government's going to say you should never pay.
I would also add, and I just done this myself, but I want to say in 2021, there was a bill introduced. I think it was called the Ransomware and Financial Stability Act. Sometimes when bills are introduced and Congress doesn't really want to push it through, they just let it sit somewhere. So it doesn't really, it's kind of, dies on the table, so to speak. But that's an example where I think Congress is having these conversations. They want to figure out a good way to tackle this. And the threshold for that was, I believe companies would have to report if there's a ransom demand over $100,000, and they would have to work with the government. So they're trying to identify thresholds to see what's appropriate. But I would second everything that Mark said. It's just a really complicated web right now.
Harley, you can go ahead and go, and then we'll wrap up.
So just on ransomware, I don't think, so I agree that it's a very complicated question whether to outlaw ransomware payments. And for the reasons that folks just said. And I think even if you did outlaw it, I think that if somebody's life is on the line, I think you're going to see CEOs violate that nonetheless. I mean, I would if it was my daughter, for example. What you do see, though, is outlawing payments to certain actors via OFAC sanctions. And there we're adding folks to the list frequently, and a lot of it now includes ransomware. It includes cryptocurrency wallets, but there again, attribution is difficult. There are more and more requirements to tell the government if you are making a ransomware payment. So that is in CERCIA, that's in the Critical Infrastructure Incident Reporting Law, and it's also in the New York Department of Financial Services, like their updated cybersecurity regulation. So we're seeing that more, but that's more for getting trends. But sort of universally, including with the threat actor negotiating companies, universally, the advice is pretty much don't pay the ransom. It's not even just whether or not the threat actor will release your systems. It's a lot of other things as well. It's not just about whether it'll encourage more ransomware. It's also often paying the ransom is not going to achieve your goals for other reasons. But I'll stop there, recognizing we're almost out of time.
All right, I'll just add one thing. Nobody wants to pay the ransom. So what can you do? Make sure you harden your systems in the first place. Secondly, have backups to your data. Have backup, maybe it's a manufacturing site that's being taken down. Well, if you have a second manufacturing site, maybe that can be protected. So preparation is a great way to ensure that you might not have to pay ransomware or not be at the mercy of these threat actors.
Amazing. Well, thank you so much, everyone. That concludes our cybersecurity panel. A huge thank you to Harley, Gang, Mark, and Daria for joining us. We will go ahead and shift gears into the NFT panel. We'll get that going very shortly, so we don't fall too far behind schedule. And just one reminder, I know we're entering lunchtime. We will have lunch for everyone at the end of the NFT panel. It'll be across the hall in one of the rooms there. Thank you.
Testing. Testing. Harley, are you there? Can you turn on your camera if you're there, Harley, so we can get a picture? Okay, there he is.
Harley, we're gonna take a picture with you in the back. Will you smile?
Am I just like a big floating head behind you all?
Harley, we're gonna take a picture with you in the background on Zoom. Will you smile?
Yes.
Amazing. Thank you.
Hey, thanks very much for having me. Take care, everybody.
Can you guys hear me on Zoom? What was that?
And someone was asking that.
They can hear you whenever you're ready. Okay, we're gonna get started in just a minute. We're letting people go to the bathroom and stand for a minute. But we'll be getting started very soon.
Okay, so you're all, yes, that's all of them. Yeah. Yeah,
We haven't started yet.
I know, we already have a question.
Okay. Well, pick out the good ones, I guess. That's what the teacher did. How about those ordinals? No one's gonna know what that.
are you guys doing today while we wait for people to come back in? You guys all found the Zoom link, so that's good at least.
What are you doing? That's just my. Can I see your handwriting?
Yeah, all right, so we're gonna go ahead and get started. Some people are still trickling back in. I'm going to give my spiel, just like everybody else did in the introduction, go ahead and then go through individual introductions. So NFTs, or non-fungible tokens, are digital assets that represent ownership of unique items such as digital art, music, and other creative content. They are created using blockchain technology, which provides a secure and transparent record of ownership and transaction history. NFTs are unique because they cannot be replaced or exchanged for something else, unlike traditional cryptocurrencies such as Bitcoin or Ethereum. NFTs have become popular in recent years due to their potential for creating new markets for digital art and other creative content. The popularity of NFTs can be attributed to several factors, including the growth of blockchain technology, the rise of digital art, and the growing interest in alternative investments. NFTs have enabled creators to monetize digital art and other content in ways that were previously not possible, and have created new opportunities for collectors and investors to participate in the art market. The legal implications of NFTs are complex and multifaceted, involving issues related to copyright, ownership, taxation, and contract law. For example, while NFTs provide a record of ownership and transaction history, it's not always clear who owns the underlying intellectual property rights to the content represented by the NFT. Additionally, the tax treatment of NFTs is still uncertain in many jurisdictions, and there may be challenges in enforcing contractual agreements related to NFTs. Given the potential legal challenges and opportunities presented by NFTs, it's important to have a legal expertise in the space. Lawyers who specialize in blockchain technology and intellectual property law can provide valuable guidance to creators, collectors, and investors in navigating the legal landscape of NFTs. And with that, I'm going to introduce our panelists here. So first we have Marta Belcher. Marta is a leading figure in cryptocurrency and law and policy. She is president and chair of Filecoin Foundation and Filecoin Foundation for the Decentralized Web, as well as the general counsel and head of policy at Protocol Labs. Marta is also special counsel to the Electronic Frontier Foundation and sits on the boards of Zcash Foundation and the Blockchain Association. Her expertise has been recognized by numerous awards, including the Financial Times Innovative Lawyer Awards and Law 360's Top Attorneys Under 40. Marta has testified before the U.S. Congress and state legislatures and spoken at the European Parliament. Next, we have Brian Fry. Brian is a legal expert in art, copyright, and intellectual property law. Fry's research focuses on intellectual property and charity law, specifically for artists and art organizations. He's also a filmmaker, producing the acclaimed documentary Our Nixon in 2013, and his short films and videos have been exhibited at prestigious events such as the Whitney Biennial and the New York Film Festival. His critical writing on film and art has been published in recent and respected journals, including October and Film Comment, and some of his works are in the permanent collection of the Whitney Museum of American Art. Finally, we have Professor Michael Murray. Michael is a distinguished professor of law and accomplished author. After practicing law for 7 years at Bryan Cave Law Firm in St. Louis, he taught at several renowned law schools, including the University of Michigan and the University of Massachusetts, as well as internationally in Florence, Italy, and overseas in the United Kingdom. Professor Murray has published 27 books and numerous law review articles on topics such as legal research, copyright, and art law. And just like everybody else, to get started, we'd like to have ask Professor Murray to present his paper and talk about it for a few minutes.
Yes, it's a pleasure to be here. Are you hearing me? It sounds pretty loud through my feedback. It's a pleasure to be invited here, and thank you very much for the invitation. The work that I have will be published in the Case Western Jolty Journal is on NFTs rescue resale royalties, which may turn out to be less impactful right now in 2023 than it was when I wrote it. So it's the wonderfully complicated ability of NFT smart contracts to allow resale royalty rights. And now I have to add a parenthetical, if the platform will actually respect and enforce those resale royalty rights that you wrote into your smart contract. But I got into the NFT world, or actually I got into the crypto world through NFTs. I was sitting with my art law materials year after year and wondering, what is this thing that is impacting artists so greatly? And through going into down the rabbit hole, it branches out in many directions. And so I've become as well read as I can be on both cryptocurrency as well as NFTs and the particular topics that we're going to be talking about today.
Thank you so much. And I as well will present my paper because I'm also being published alongside Professor Murray. My paper isn't talking about NFTs per se, but digital assets in terms of things like the metaverse or video games, to be more specific, thinking about how do we value property rights in something that could technically be created ad infinitum? How do you vest people's labor with property rights when you can create something seemingly forever? And talking about that from a more philosophical and economic standpoint, thinking about the origins of a lot of our property law, John Locke, and thinking that through understanding how to not ruin the common for everyone else and how to deal with those disincentives that come when you start pulling from a digital asset forever. And I will also keep my explanation brief because I know we're already a little bit behind, and we'll jump right into some of the questions. Please feel free, anyone who feels comfortable right away, to answer the questions. So what are some of the key legal challenges surrounding NFTs and how might they be addressed or resolved?
All right, I'm happy to jump in here. So I think one of the things about NFTs that is really confusing for people, I think even lawyers, but especially non-lawyers, is this idea of when you buy an NFT, what have you actually bought? Like what rights does that actually give you? And it's quite confusing, right? Because you've bought this thing, and you assume that you can, do stuff with it, and that maybe you've actually, bought the underlying rights to the work. But I think the headline here is buying an NFT and has absolutely nothing to do whatsoever with the intellectual property. And so what can happen is when you buy an NFT, you can separately contractually enter into an agreement where you also get rights to use the underlying work in some particular way, right? You can do that, but that's not a given by virtue of merely having bought the NFT. So I think that's like a really important headline and something that is not well understood. And I think that it's also, I'm happy to dive into this a little later, but I think there's, as a result of that being a problem, there are a lot of different folks who are trying to address that by creating kind of standardized NFT type licenses, which is great. And I will gladly dive into this more later, but I think that the way to go there is really for us to, as a community, use Creative Commons licenses rather than reinventing the wheel. I will now hand it over to Brian Fry. I just want to say I'm so excited to be on this panel with Brian. I've been waiting for this. I've been waiting for this moment for 4 years since I got Brian's SEC no action letter request ownership certificate in the physical mail. So I'm delighted to be here, and I will hand it over to Brian.
Well, back at you, Marta. I'm so excited to meet you virtually in person finally, and it's great to be on a panel with my colleague Mike as well, who's been doing great NFT related work over the last several years. So in relation to the question that was posed, my hope is that the NFT market or something like it will help finally make copyright obsolete. My hope is that we can finally move away from a world where we define information and the consumption of information in terms of scarcity, and we can embrace the abundance that digital technology and the internet made possible finally for the first time, right? So several years ago, Amy Adler wrote a really fantastic paper titled "Why Art Does Not Need Copyright." And I think, or I hope, that NFTs and the NFT market show us why nothing needs copyright, because NFTs give us a way or show us that it's possible to engage in the relevant forms of financial transactions around creative works in ways that don't require scarcity, that don't require limiting access to the works themselves. And I think that ironically, one of the reasons that so many people object to or don't understand NFTs is that we've internalized scarcity, we've internalized ownership, we've internalized control in the form of copyright so deeply that it's basically impossible for a lot of people to imagine a world where everything is so abundant that you don't need to control it anymore. But I think we can get there.
If I can be the tail end of this comment, I think some of the largest issues with NFTs just relate to how are they going to be treated like property, and are they going to be, the kind of property that can be seized? That this is the kind of property that you can foreclose on. Are they going to be property that you can use as collateral? And then the separate, the separate topic of that Marta touched on, quite well, which is, what does it mean to own something when you own an NFT? And are you buying an NFT to try to reflect the ownership of an actual digital asset or an actual real world asset? Because people are selling NFTs that are been linked or connected to everything that you can, well, many things that you can think of. And we're just beginning to scratch the surface on that. I mean, there will be NFTs for services, there will be NFTs for membership, there'll be NFTs for access. And if the IRS is wondering how the heck do we tax it? Of course, they will tax it. That's going to be a given, death and taxes. And if they tax it, are they going to tax it under more favorable conditions like capital gains, or are they going to continue to tax it like a basic collectible? Like if you have a baseball card and you sell it, then you have to come up with what your basis was when you bought it, and then you'll be taxed. And hopefully they will come up with smart laws on that. They're asking for comments now, so if you're concerned, weigh in. But those are the points I would add on to what other people have said.
If I can jump in for one more moment, again, I think it's actually really important to recognize that NFTs are a technology, but a technology that can be used in lots of different ways, right? So NFTs are already used in like supply chain situations to solve problems, technological problems that arise in a really broad range of contexts. I'm interested, at least today and in most of the scholarship I've been working on a particular application of NFTs, or a particular area in which they function in order to facilitate a certain kind of market transaction. So I think it's important to kind of ask, what use of NFTs are you interested in? And so I'm specifically interested in the NFT market, i.e. kind of NFTs used as a way of representing some kind of ownership in something else. And it could be really anything, which I think is what's so delightful about it. And I think I know how they work, right? I think I know how the market works, right? And I think that they show us something really interesting about how the markets for creative products can work. Because I think what the NFT market shows us is that the art market has always been a securities market. We just couldn't see it because the objects got in the way, right? People thought when they were buying art that they were buying a painting or a sculpture, but they weren't, right? What they were really buying was a dirty piece of cloth or a lumpy rock that represented something. It represented an investment in the career of an artist. It represented investment in clout. And that's all it is, right? It's a security interest in the belief that somebody's going to be cooler in the future than they are today. And that sounds so stupid, but it's actually this incredibly powerful tool. Because if you can securitize clout, if you can securitize social value, it means you don't need to have control anymore. You don't need to limit access to information anymore, because now people can monetize their social value, their social presence, without having to limit. And in fact, there's a kind of synergy, right? Because historically we thought the way that artists and authors had to make money off of their activity was by limiting access to what they do. But the NFT market shows us that you can actually maximize the value by making whatever it is that people care about more available to everyone rather than limiting its availability, right? If you monetize clout rather than monetizing access to information, what you get is a world in which you want to make things as available as possible. You want to maximize the abundance of works of authorship rather than create this artificial scarcity that we've always assumed was necessary, right? So I mean, my take on this is that, look, copyright was a great tool when we invented it hundreds and hundreds of years ago, right? It was a way of solving market failures that we didn't otherwise know how to solve. But all those market failures, all those transactions costs that copyright was designed in order to solve, they're gone now. They went away. Copyright went from being a way of solving market failures to being the market failure, right? And it's okay, we can just put it to bed now, put it to rest and move on. We need a new policy tool. And I think maybe we've found one.
I would love to add to what Brian just said, which I think is, first of all, absolutely brilliant. And I completely agree, and certainly could not have said it as well as Brian said it. But I want to add, like, for me, one of the coolest things about NFTs is that if you're an artist, you can actually sell an NFT. And at the same time, what you can do is you can take that underlying work and you can actually dedicate it to the public domain, or you can Creative Commons license it, right? So you can simultaneously monetize something and actually make money from it. And then at the same time, that underlying work can be dedicated to the public domain. And I think that is so potentially powerful and something that I really hope that more people will start to do.
And you all have kind of preempted at least two other of my questions with your answer to the first one. So good job. Love the excitement. So let's shift then towards how might or what role might emerging technologies such as AI and machine learning play in the future and development of NFTs as well as the regulation of them?
Well, okay, so I hate that. I'm going to take the privilege of jumping in here because I'm actually working on a project about this right now. I fear a lot of people are asking a lot of really uninteresting questions about artificial intelligence, right? So the conversation I see, at least in the kind of intellectual property space, is one, can copyright or should copyright protect works generated by artificial intelligence? And two, are LLM AI models a form of copyright infringement? I think both those questions are both easy to answer and not very interesting, right? First off, the copyright, should the works be protected by copyright is just a silly question. Why would we want those works to be protected? Copyright's just a policy tool. It makes no sense to do that, right? And the question, should they be infringing, is equally pointless to ask, right? Why would we care, right? I think the interesting question to ask about artificial intelligence and the kinds of works generated by artificial intelligence is, what do they tell us about what we're protecting in the first place, and why, right? Because I think one of the big mysteries in copyright doctrine and theory is, what are we trying to accomplish in the first place, right? I mean, fundamentally, we say that when we grant copyright protection, what we're trying to do is incentivize creativity. The problem is we don't know what creativity is, right? And I think the beautiful thing about artificial intelligence is that it shows us that almost everything we conceptualize as creativity isn't. It's just bullshit, right? Because AI LLM models, they're just bullshit generators. But when people can't tell the difference between the bullshit generated by an AI and what they think is creative because it's produced by a person, what that should tell us, right, is that none of that stuff was creative in the first place, right? So we've always had this question, how do we know what's creative and what's not? Everyone comes up with their own pet answers, but I think I have a better answer. We should ask the machines, because the machines can tell us with 100% reliability whether or not what we've produced deserves protection, because the machines can tell us whether or not they could do it themselves.
Well, Brian and I we are colleagues at the University of Kentucky. I disagree with Brian about the need to throw away copyright. I actually believe strongly in copyright. And I do agree, though, that the questions about artificial intelligence and copyright, I think we're asking the question, or at least we're framing it wrong. That I think the first panel, if I could remember the name of the person who said it, I think it was Professor Tibbs, I believe. He said that artificial intelligence is a tool, which basically, if you say, what do you mean by that? It's like Photoshop, 20 some years ago, Photoshop came out in 1987, I believe. And, people are like, oh my gosh, you'll be able to copy works and then do your own thing with them. And it'll be so fast. And, we don't have to slave over easels anymore. And it didn't change the art world. It didn't crush creativity. It didn't crush innovation. It may, as Brian says, reveal some things about creativity and innovation that we'd just as soon not look in the mirror and see. But this artificial intelligence, the question of whether the work is created by the artificial intelligence, it's not. The work it's a tool out there that does fantastic things at fantastic speeds, and it makes people who can at least express an artistic idea in a string of words able to generate art that they couldn't generate otherwise, because they didn't know how to use available means until artificial intelligence gave them the ability to describe, I'd like to see a picture that incorporates this, and then say, oh, that's a pretty good one. Why don't you change it to do this? And then you add more prompts. That is the person generating the art. That is the person creating the art. It's a human being creating the art. The question of whether unfortunately, the Copyright Office has bought into this false framing and this false narrative that the artificial intelligence is just there like the genie, in the bottle, that you say, please do something today. And it says, well, I've created a work and here it is. And do you like it? It's not. It's not how any of these diffusion models or anything work. You don't go to home one night and then they'll say, hey, did you have a nice day at work? My artificial intelligence, I just created 10,000, new pictures. You want to look at them? It's not that at all. It's me using the tool. It does things so much faster. It does things so much more powerfully. And yes, that is a threat for people who work very slowly and generate very similar types of images and so forth. But that's, I find that's just a false narrative. It's a false framing of the question. About who is the author of AI generated works. The author is the human being who, uses the tool to produce the work and makes a very careful choice at the end of the process to say, of the 8 images you've generated, DALL-E, or of the 4 images you've generated, Stable Diffusion, I like the second one, let's work with it. That's creative choice right there. You make a choice, just like if you set up a camera on a sidewalk to take random passerbys and you remotely operate the camera, you're not framing, you're not picking composition, but you do get a series of generated images like DeCorsia does. And you pick of them, these 13 are great. And that's just what I want. You're the artist saying these 13 are great. That's just what I want. Same thing on Stable Diffusion. Excuse me, on Stable Diffusion. This 4th one's great. Let's run with it. And that's what that's basically it. I'll end it there.
Yeah. So when it comes to NFTs and AI, there have been sort of 2 use cases that I've seen, both of which I think are pretty deep cuts, right? Like, I mean, this is like getting very, very far out there in the world of emerging technology. So one of them is, so obviously Sam Altman is behind OpenAI, and Sam Altman is also behind WorldCoin. And those 2 things are part of the same sort of master plan, so to speak. Maybe I shouldn't use that word. But so the idea with OpenAI is, of course, you're creating this world where there's going to be so much AI generated content, right? So there is just the internet as we know it today, right, is much of it is generated by humans. And if you fast forward 3 years, maybe even 3 months, right? Just imagine the amount of the internet is going to be AI generated work, right? I mean, we are sort of at this moment in time in the internet where I think the internet of the future is going to look very different. I mean, imagine the problems with bots that are very, very convincingly like humans, right? And text that is very convincingly human are some of the major problems that we will face in the coming years because of this really powerful technology. So why is WorldCoin part of this? Like, why does Sam Altman care about WorldCoin? So what WorldCoin is, there was actually, before OpenAI sort of bursted onto the public scene, there was a lot of controversy around WorldCoin. So what WorldCoin is they sent out these orbs, like literal physical orbs, to take retina scans of people, and then all over the world. And the sort of vision for that is that in the future, everyone in the world will have their sort of retina scanned by this orb, and it sort of gives you a token that proves that you are a human. So each person kind of has the ability to prove they're a human. So that sort of is part of the master plan, and goes hand in hand with OpenAI, because in a world where on the internet you have no idea whether any given person is a human or AI generated, you need some way to prove that you are a human. And so that is the sort of thinking behind WorldCoin. Is it a good idea? Does it have insane privacy implications? All of those things. I speak to none of that. I merely note that there is a connection between the master plan of NFTs as proof of humanness and the problems with AI. So that's one use case that I think is really interesting when you get into, again, extremely deep cut. The second deep cut is another extremely deep cut here. So we've been talking about these problems with AI and copyrightability. When it comes to AI and copyrightability, I think there are three major questions. So the first question is, when it comes to inputs, so if I'm an AI model and I go and I scan a bunch of text on the internet, right? Or scan a bunch of text, do I have the right to do that? Or do I need a license to do that, right? Is, I think, the first major question around copyrightability. The second question is, okay, if there's an output that is too close to something that is already existing, is that copyright infringement? So that's the second big question. And then the third big question with AI and copyright is an AI generated work copyrightable? So I think there are sort of like somewhat like interesting, but again, very sort of far removed ideas for how to integrate NFTs into these problems. The one that I've actually seen out there in practice is this question around inputs. This idea that somehow you can use NFT technology to make it clear when, you know, whether, like, how something can be used as an input into an AI generated model. So that is the way that I've seen like NFTs being used in the AI copyrightability space, like in real life. The problem with that for me is I actually think I much like Brian am heavily on the copy left side of things. And I actually think that today's law in the United States, as it should be, you know, really is that when it comes to inputs, you should be able, an AI should be able to go out there and scan anything and everything, and that should be per se fair use. And I believe that our current laws actually stand for that proposition. And so the idea of taking an NFT and like giving people permission to do that or not is a nice idea, but like I think it fundamentally goes against what is the important policy and what is the law now, which is no, actually we can just go scan that. I will stop.
Yeah. So just to pile on to what Marta was saying, I like to observe that art is a consumption good that consumers don't understand, right? And what AI shows us is that consumers don't want art. Consumers don't like art. Consumers like bullshit. That's what consumers want to consume. They want to consume as much bullshit as possible. And when you serve them up art, they either don't notice or they don't want it, right? That's not what they're looking for, right? And, you know, 60 years ago, Roland Barthes told us the artist, the author was dead. I think what these AI models show us is that the author was never alive in the first place, right? That the author was always a figment of our imagination. And the reason that these AI models make people so uncomfortable and upset is they don't like to admit it, right? But for me, there's something really kind of deeply pathetic to see people call themselves artists and then complain about having to compete with a machine, right? If you can be outcompeted in expression by a machine, you should stop, right? Why are you doing that in the first place, right? What you're producing isn't art. It can't be art, because what you're literally telling me is you're being outcompeted by a bullshit creator.
There certainly is a lot of fun stuff in the NFT world. Shifting over to something that is even more specific and specialized, and it might require some explanation on whoever chooses to answer first. What are some of the potential risks of using ordinal values to represent unique assets in NFTs, and what steps can be taken to mitigate those risks from a legal standpoint?
I'll jump in on that. Because I suggested to the organizers that we talk about ordinals. I don't think that they present brand new legal issues unless, again, I'm very new to the concept of ordinals, although I do remember, the Pepes of years gone by. But the difference here is that we're not dealing with the Ethereum blockchain, we're dealing with the Bitcoin blockchain. And the difference is there are no smart contracts. So the things that we have come to associate intimately with NFTs is the smart contract and the ability to program it to do things like try to get resale royalties if the platform will now cooperate with the enforcement of resale royalties. But with ordinals, you're dealing with Bitcoin. The big difference is there's lots of mechanisms to on-ramp your artwork or your asset or your privilege or your governance token on the Ethereum blockchain. People have made that a science. And Brian is one of the people on this panel, I don't know if Marta is, who has actually created a bunch of NFTs and sold NFTs and so forth. With ordinals, you have to really be a strong Bitcoin level programmer to have to control a node. And I certainly am not. It's not like going to OpenSea and just using their prepackaged on-ramp to create an ordinal. But the ordinal does create a record on the Bitcoin blockchain, which of course is the strongest and oldest. So that's the interesting part of it. Now, whether it empowers something new and different, I guess it will remain to be seen. It's only since December that this has caught the attention of Bitcoin maximalists and other people who would just as soon be on the Bitcoin blockchain. And then again, maximalists would probably say, stop doing ordinals. You're confusing us with people who create that art that's on the Ethereum blockchain. And we want to be gold, digital gold. So that's what I guess is. Now, perhaps I'm missing, a part of that, but I'll leave my answer at that.
I mean, I guess I could chime in really, really quickly to say that I see the NFT market as essentially being a market in search of a product, right? And that's one of the reasons I find it so exciting, right? Because the reality is it's a market for content that just isn't that interesting yet. And yet there's an incredible amount of demand anyway, despite the fact that there's basically nothing worth actually buying. So what that says to me is that the NFT market is revealing a kind of latent demand for a way of restructuring our market for creative goods that's far more powerful than anyone fully appreciates right now. And I just can't wait to see what that looks like when the content available, when the value available to the market represents things that people actually care about and want to be associated with, because as it stands, there's just not that much there, and yet people want to buy it. People want to buy it anyway. So I think that that's really exciting, and I'm looking forward to seeing how this market develops in the future and where it goes. I don't have any idea, but I'm optimistic.
Well, Brian, there is some good stuff out there in the NFT market. Most of it minted by you, let's be honest, including but not limited to your works based on prints to protest excessive copyright protection, of which my boyfriend owns 2. So proud owner of 2 Brian Fry NFTs. So look, there is some gold out there, let me tell you.
So moving back to the role of the legal system in NFTs, what role can and should the legal system play in regulating the market for NFTs? And is the possibility of self-regulation by the industry sufficient?
Well, I've been trying to get the SEC to regulate me and they won't return my phone calls. And it makes me feel really bad. I really wish that Gary Gensler would come and regulate me already.
Well, get in line behind Coinbase.
But more seriously, right? I actually think there's a lot of room for potential productive regulation. What concerns me is that I don't think the regulators are taking their job as seriously or as thoughtfully as they should, and I find that really disappointing. Right? I expect more of our regulators. I mean, I believe in regulation. I think there's a lot of room for regulators to step into the space and make these new markets work more predictably, work more efficiently, right? To follow those kinds of, or kind of pursue those kinds of goals that we say we expect regulators like the SEC or the CFTC or the FTC or whoever to pursue, right? Goals of, making the market work more efficiently and providing for consumer protection. I think those are really important goals, but I think that their agencies have a responsibility to think long and hard about what their institutional competence is, what they can do effectively and well and what they can't, to ask what kind of regulations will actually make the markets work better and what kind of regulations will actually protect consumers, as opposed to just kind of doing whatever they've always done in the past or just saying no, right? I don't think that strikes me as a real abdication of their obligation as public servants who are supposedly pursuing the public interest. I expect more from them.
Well, I love everything that Brian just said. Michael, it looked like you were about to dive in, so let me defer to you on this.
Oh, no, I was very happy to let you dive in. So you go ahead.
Okay. Look, well, first of all, big fan of all of Brian's securities related conceptual art. And a lot to say about regulation. I think, should NFTs be regulated by the SEC? Gosh, I sure hope not. I mean, like, can you imagine a world in which art is like, you literally have art and that is regulated by the SEC?
Oh, Marta, I have volunteered to lead the SEC's conceptual art division as soon as Gary creates it.
Look, that would be an expansion of jurisdiction that I think might be some
Not
people
under
might be
Brian.
in favor of.
Not under
Yeah.
Brian. It would be laissez-faire very much.
Yeah. But what I will say here is I think that there's a lot of people are thinking about ways that NFTs are that we need to create new legal structures around NFTs. And that includes things like, for people who believe that copyright should continue to exist, which is not everyone, and on this panel, myself included. But I think for those people, there's a lot of sort of developing new license regimes, ideas. A lot of people have the idea of like, oh, we have this problem, or we don't really know when you buy an NFT what you're actually buying. Like, we're going to create a new license for that. And that is super great. And I'm glad that people are thinking about that. But it's sort of like the XKCD problem, where you're like, there are like 13 standards. And I think what I'm going to do is create one unified standard. And then you now have 14 standards, right? Like this is sort of where we are in this sort of creation of licenses around NFTs. And the fundamental thing is, we already have a great way of solving this problem, which is to just use Creative Commons licenses. Like, Creative Commons exists for this exact reason, which is to make it really easy to know how something is licensed, and to know whether it's dedicated to the public, if it's CC0, or whether you can use it, but you have to use attribution, which is CC BY, or whether you can use it, but only for non-commercial purposes. Like, there's a really easy way to label works of like, how can you use this thing? And it's Creative Commons. And so one of my big messages to people is, first of all, look how great, as I said earlier, look how great this is. You can now monetize your thing while dedicating it to the public domain. And second, just use Creative Commons licenses. Like what you should do is you should monetize your thing by selling an NFT and dedicate it to the public in some way, or at least Creative Commons license it in a way that's more open than just retaining all the rights.
And I just really quickly, we do have a lot of questions from the chat. So if you could just put some closing thoughts on this topic, and then we're going to move on.
Yeah, I do have a few closing thoughts on this. And I think the problem, and I'm guessing here, but I think it's probably right, is that what we have is a situation as if we invented 3 years ago, 4 years ago, agriculture. And some people said the only way to do it is to naturally collect the seeds and you plant them in the ground, and that's the only way to do it. And somebody else said, no, we can do it differently. We can do genetically modified. We can make better seeds. And somebody else said, I want to build my seeds in a walled garden, and you can only get in and out if I say so. And other people said, no, we should grow it all on a hill over here where everyone can use it. And, if you come up with a better idea for using the plant, it's yours, take the idea away. And, of course, that's great. And I do believe, other than the 1958, political connotations, the word of let 1,000 flowers bloom, that this is a great way to approach a topic that does have this connection to the creative world. The problem is, what does the regulator do with that? No genetically modified, no commons. We're going to shut down the commons. It's going to be a walled garden for everyone, and you got to plant things, and maybe organic will be the only difference. You can plant them this way, or you have to follow organic rules. And I'm thinking that that's the problem that these regulators have, is people's experimentation in this field is fantastic. And we haven't even begun to talk about the future, like when we have the metaverse and we have alternate reality and mixed reality and virtual reality, that you need things to own in virtual reality. And this NFTs is it's existing, that you have the ability to have this control over objects that you can move from, different walled gardens or just throughout an open metaverse experience. And that's cool. So I sympathize with the regulators, but I guess I'll leave it.
Thank you.
Just really briefly, I couldn't agree more with Marta. NFT art wants to be free, right? NFT art wants to be free. And I think the center of gravity of licensing in the NFT world will always be, and has always been, no licensing. Right? And I think the only reason it's hard for people to see that is, again, we've internalized the idea of ownership so profoundly, right, that copyright turned us all into landlords, but we don't have to be landlords, right? We don't need landlords anymore. We can do without.
Thank you so much. And now we're going to turn over to some audience questions. I know that we have quite a few to get through, so we'll see how many we can get through. Anyone in the audience or online?
Well, we'll go with an online question. Kirsten Rempe asks, how is the risk of using NFT for money laundering countered right now?
I'm generally pretty unconcerned about crypto and money laundering. And honestly, I've never really understood why people go to money laundering when they're thinking about what kind of problems are likely to arise in crypto-oriented spaces. Because honestly, I'm not that into criming, but if I were, the last place I would be criming would be on the blockchain, because you're literally making a public record of every criminal transaction you're engaging in. If I wanted to do money laundering, cash is right there. Cash is right there.
I think that if you want to actually, I think what Brian said is absolutely right. I mean, this is like the most foolish people in the world, the ones who took their Bitcoin thefts and said, I could just, run away with all the money. And they found out that, it may take a couple weeks, and Chainalysis has to track you down, and Chainalysis is getting better and better at tracking you down. And the government uses Chainalysis as an outside contractor. So and they'll find you. So basically, the next topic is the zero knowledge topic. But the zero knowledge topic, as far as I understand it, is going to be built around a technology that when the government needs to exploit and find out who actually is behind these information in the zero knowledge rollup or the zero knowledge proof, that who is it? The government will get it, because the zero knowledge people don't want to be Tornado Cash. You know, they don't want to be like the non-existent owner of Tornado Cash who doesn't exist, but they don't want to run Tornado Cash or, you know, years ago, Pirate Bay or whatever else. So that's, I think, you know, that the next topic is how do we maintain privacy up to the point where there's a serious reason to invade the privacy for law enforcement.
Okay. Musa Hakim Jr. asks, take Google or Instagram as a reference. In the event of a public blockchain where participants are limited only to sign up and the information is not owned, but sold and shared without direct transfer of IP or rights ownership, would these NFTs still be subject to issues regarding ownership of the original creator? In the same way, Elon Musk can't sue me for getting a lot of likes for an image of him, but he can if there is a situation where I directly benefit from being depicted, interpreted.
Well, Marta, I think, answered this question right at her opening. There's a big difference between the underlying asset and the NFT. I mean, the NFT is a registration tool, and it does create this immutable registration on one of the blockchains, usually Ethereum these days. But that's the only difference here. You know, if you have an Instagram photo that you really like and you make an NFT out of it, then you can sell the NFT, keep exploiting the photo, or as Marta said, donate the photo and, you know, sell the NFT. And Brian has pointed out, owning the NFT may be the only thing you want. I mean, there's whole industry out there that'll sell you a pair of fantastic sneakers and you will never touch the sneakers, but you will own that, you know, NFT with the sneakers to show that you're the coolest guy in your group. So that I think it's a difference of, it never really affects the ownership of the underlying act unless you take the next step Marta described, which is you do transfer something. You transfer a license to do this, or you transfer the complete ownership. You actually assign the complete ownership of your through a separate way. It's not, the NFT never does it automatically. You have to go take some steps to make it happen.
Yeah, I mean, if I can make a really quick observation, right? If you buy a share in Google or a share in Tesla, at the end of the day, all you really own is the right to sell that share to someone else. But no one seems to think that there's anything weird or troubling about that whatsoever. And then you tell them about NFTs and they're like, oh, I don't get it. What do you own? Why would you? Like, it's literally exactly the same thing. What's the problem? What are you so confused about? Why do you think this is so weird? We're just securitizing something new. And that shouldn't be so surprising or hard for people to wrap their heads around, but it is. And I think that that's really interesting.
Yeah, and the thing is, this is new and different because it is, you know, diversified. It is spread out. It is not centralized control over this. It's not some government granting you a property right that they can then take away. And that's what, of course, is the revolutionary part of it. So you're registering something, let's call it a painting, but you're putting it on there to create an immutable record that you're connected to it. And then, as Brian said, and the excitement is, I own it. It's the ownership excitement of owning it. And then you transfer it and somebody else gets the excitement of owning it and having a record that's on the blockchain, and it's supposedly immutable. Now we're not going down the road of talking about forks, but anyway, it's supposedly immutable.
Yeah, just completely, like, could not agree more with Brian. Like, in general, I am sort of surprised by the like anti-NFT arguments around like, but you don't own anything. Or like, why would anyone want that? Because especially like, I mean, Brian made a great point in the context of sort of companies, but like in the context of just regular old art, right? Like having an original painting that is like, and owning an original painting and having it be the thing that you own and you have on your wall, like may not be any different than having like a copy of it, but like that matters to people, and people will pay millions and millions of dollars for the like original just to say they own the original. Like this is not a weird or unusual concept in regular art. And also like similarly, like we keep hitting on this point, which I think is a really important point, owning the painting, like owning the physical painting doesn't mean you own the rights to that painting, right? Like same deal. So it's actually like not that new or weird or different. Even just in the art context, like this is really quite similar. And I'm surprised how much people push back against the general concept.
Yeah, that's exactly right. Because the art market has never been a market for objects. The art market was always a market for entries in an artist catalog raisonné. It was always a market for ledger entries. We just couldn't see it because the objects got in the way. But all the object is a dirty piece of cloth or a lumpy rock. It's a physical token that represents ownership of the entry on the catalog raisonné. All the NFT market did was get rid of the physical tokens and let you trade the ledger entries directly. It shouldn't be a difficult concept for people to understand, but we've internalized the idea that the art market is a market for objects, which was always wrong.
I think we have time for one more question.
Anyone in the audience?
No, we have a lot of questions from the online people.
All right, we'll do one more from the online. This is from anonymous attendee. Isn't the demand for NFTs and cryptocurrencies heavily tied to celebrity promoters? If Reese Witherspoon tells you you need a crypto wallet, you must need one, right? Is there demand to own bullshit or to be like Reese?
Why not both? Right? I mean, to my mind, look, the example I like to give is the Kardashians, right? Because it is bullshit, but people love bullshit. That's the point, right? So the Kardashians, they couldn't exist, right, as a Kardashian brand without Web2, right? They needed social media in order to be famous, in order to develop the brand that they did. And by using social media, they generated a massive amount of social value, right? Think about how many people are talking about or thinking about Kim Kardashian right now, like vast quantities of social capital being generated by them. They make a lot of money, but they only make a tiny fraction. They only internalize a tiny fraction of the social value that they're generating. Why? Because they have to do it all indirectly, right? They have to do endorsements or sponsorships or make products, right? And it's hard. There's lots of transaction costs associated with that. So they only get to internalize a tiny percentage of the social value that they generate. What's cool to me about NFTs is it means that the Kardashians can just sell securities in their own fame. They can sell their own clout directly to speculators who want to bet on whether the Kardashians are going to be cool and popular in the future. And that means that they can internalize a much larger percentage of the social value that they're generating. And not only Kim Kardashian can do it, but everyone else can as well. What we're doing is giving creators access to capital markets for the first time ever. And I think that is transformational.
Yeah, I would love to jump in to follow up, because what Brian said is absolutely right. When you think about musicians, and NFTs are trying to claw their way into the musical recording market, you know, they create a song, they put it on Spotify, they get tiny, ridiculously small amount per download. And if instead you sell a fractionalized interest in the song, and then, you know, all of a sudden you have investors who are putting crypto money into your pocket, and these people collect, if the song does go incredibly popular and viral, then they are the beneficiaries of it. But it's true, you don't need that. You could just take your publicity value, fractionalize it, and then have a person own a piece of you. And then as long as you keep yourself popular, then those people benefit along with you, and they have the access or the fun or the ownership value of being, I'm a owner of a fractionalized of my favorite, you know, Taylor Swift, the Kardashians, whoever.
I think, Marta, if you have a closing remark on it, we just want to finish up and get everyone on their way.
Sure. I will have a closing quick remark, which is to say, you know, I think one thing to note, like zooming out bigger picture, when it comes to not only NFTs, but also cryptocurrencies in general and this technology, I really think that the price is actually the least interesting thing about it. I think it's the thing that is actually really interesting about this technology is the cool stuff that you can do with the technology. So that would be my sort of big picture closing remark.
Awesome. Thank you so much for participating. I really appreciate you guys coming and taking the time out. And to everyone who came to visit us during our panelists, we're going to have a few closing remarks from Nupur, and then we'll all be on our way.
Thank you all for coming today. It's our annual symposium. And once again, thank you to the Spangenberg Center of Law, Technology, and the Arts and the Frederick K. Koch International Law Center for helping us make this event happen. And lastly, a big thank you to Jolty staff for their hard work this year. We couldn't have done it without you. And yeah, thank you.